Yes.
If to mention for listing of an admission matter on Friday, my lord.
What is the subject matter?
My lord, petitioner bank account has been freezed, my lord.
Huh?
Petitioner's bank account has been freezed, my lord.
May I please, Lordship, with the consent of other side, Lordship, I beg to mention item number 30. Here, Lordship, I am awaiting the instructions. Let it come after
30.
30, Lordship.
Yes, Mr. Dutta. Mr. S. Dutta, learned counsel for the petition is present. Mr. S. S. Roy, learned government advocate. It being for a state respondent has sought for how much time?
Lordship, 3 weeks, Lordship, after the vacation.
Further 3 weeks time to complete his instruction in the matter. Is it allowed to release the case on so-and-so?
Date may be fixed, my lord.
22nd July.
Oblige, Lordship.
I beg to mention item number 8, 9, and 10, my lord. Some matter, my lord.
Yes.
My senior is not giving all today, my lord. Matter will be taken on Friday, my lord. Kindly.
Okay, on the prayer,
K. Kolita.
take will release the case on so-and-so. It is submitted, consent has been Friday.
Oblige.
1906.
May I please, your lordship, with the consent of the other side, I beg to mention item number 31, 32, and 49 of the supplementary list.
31.
31, 32 of the daily list and 49 of the supplementary list, lordship.
30 to 31, 32 and
49.
49 years.
Lordship, in these all 3 matters have been allotted to us. Earlier, this was conducted by some other council. Lordship, I require some time to file my affidavit in these matters.
Okay. Petitioner, yes.
Lordship,
Mr.
I am for a petition.
Bora,
Yes, your lordship.
Mr. P.K. Bora, Learned Counsel for the petition is present. Mr. K. Joint, Learned Counsel on behalf of Mr. Esika,
Lordship.
Learned Senior Counsel and Special Counsel,
Counsel.
CGST,
Lordship.
has submitted that the brief has been handed over to them, to him recently, and he needs 3 weeks time
Lordship.
to file counter affidavit on behalf of the respondent CGST authorities. The Mr. Bora, Learned Counsel for the petitioner, has no objection to the prayer. The prayer is allowed, leaves the case on so and so. After 3 weeks, then
Lordship.
after 3 weeks,
24th July.
3 weeks for filing of counter affidavit by the respondent CGST authorities. The interim order.
Yes, your lordship.
The interim order passed earlier shall continue till the next date of listing. Same in 32 and
49.
49.
2407.
Pleasure.
Lordship, item 12,
Yes.
my senior couldn't be present because of some personal difficulty. So can the matter be listed after vacation?
Yes.
Lordship, I am there.
Miss
You, Thakur.
E. Thakur, Learned Counsel, on behalf of Mr. A. Kanodia, Learned Counsel for the petitioner, has sought listing of the case after the ensuing long vacation on the ground of personal difficulty on the part of Mr. Kanodia. Mr. K. Joint, Learned Counsel, on behalf of Mr. S.C. Kyle and Senior Counsel and Special Counsel CGST, has submitted that he has no objection to the prayer, has sought for and agreed to by the Learned Counsel for the parties, lays the case on so and so. Any interim order?
Yes. Lordship, I don't remember.
Chekuilo.
2307. 23rd July.
Much obliged.
Much obliged.
Make legal worship. My lord, I beg to mention item number 24 with due consent from the other side.
24.
24 admission. I pray lordship, 2 weeks time lordship, file additional affidavit, some developments there and. also
Mr.
mention-
K. A. Mozumdar, Learned Counsel for the petitioner, has submitted that he may be allowed to file an additional affidavit to bring in subsequent developments
Lordship.
in the
And
matter.
that-
It is submitted that consent has been taken from the Learned Counsel for the respondents to make the prayer as sought for, release the case, as sought for, release the case on
After vacation.
other vacation.
Lordship and interim order lordship.
The interim order passed earlier shall
Inadvertently, last occasion it was not.
the interim order,
Earlier continued.
if any
Interim
passed
order
earlier,
was
shall
not there,
continue
but
till the
last
next date
order-
of listing.
That was not. mentioned.
22nd July.
May I please, your lordship, with the consent of the other side, I beg to mention item number 19, your lordship.
Yes.
Lordship, can the matter be taken up after vacation, lordship? I've taken
Okay, you have
consent.
informed the other side.
Yes, Your Lordship, they are here.
I'm appearing on behalf of the
Miss-
petitioner, Your Lordship. Your
Miss-
Lordship, a date can be fixed.
Madam, your name, please.
Sorry,
Name.
Mzo Manpuri.
Mantul.
We have all the petitioner is present. Mr. R. Google, Standing Counsel Forest Department, has sought a listing of the case after the ensuing long vacation in July.
Mhm.
Okay, as the prayer is not opposed by the land council for the petitioner, lays the case on so and so.
2707, 27 July.
Obliged, Lordship.
Can it be on 23rd?
File over list. given us.
23rd Tuesday.
Friday,
Obliged.
normal day. Any interim order?
Is it in-
No.
No.
Thursday. 27,
Obliged,
2707.
May I please your lordship? Lordship, I would like to beg for listing of a IA.
Or
Lordship, in this case, cell permission was cancelled during the pendency of writ petition.
what cancellation?
Cell permission.
Okay. Pending,
Yes,
pending
lordship.
petition.
Yes, lordship.
Give it to the court, master. Give it to the court.
May I please, your lordship? My lord, I have filed a repetition silencing the eviction notice on my Patta land, lordship. But can the matter be taken today, lordship, as unlawful matter?
Tomorrow,
Obliged.
Yes, Lordship. Lordship, item number 43, Lordship. I pray for an adjournment for 2 weeks, Lordship, because the dealing council, Ms. R.D. Mazumdar, is out of station, Lordship.
let us see order matters. We'll see. We'll adjourn accordingly.
May I please, your lordship, prayer for listing a repetition, lordship, on 17, lordship.
What is prayer for writ petition in the motion
Prayer for
column?
repetition is,
Motion column.
no,
Lordship,
admission matter.
What is the
Service
subject matter?
completed, lordship. Admission matter, lordship.
What is the subject matter?
Subject matter, lordship, discriminatory distribution of the MGNREGA fund and 15 finance fund,
Give
lordship.
it to the court, master. He will give
Right.
the date.
May I please, your lordship? Lordship, I beg to mention for listing of a repetition for admission column. My lord,
Subject matter.
Matter pertains to my lord, freezing of bank account, my lord.
Give it to the court, master.
Much obliged.
May I please, Lordship, I beg to mention item number 37.
Yes.
Lordship, due to inadvertence, we were unable to complete our steps on respondent number 6.
Let us see what is not complete.
Lordship.
Hold on. Daily list for motion, item number 1.
Please, Your Lordship. Item may pass over time being. ma'am. Obliged.
Item 2.
May I please, your lordship? My lord, my senior GK Mishra is online.
Yes.
May I please, your lordship? My lord, this writ is filed challenging inaction on the part of respondent number 3 to comply with the order of State Information Commission dated 21/5/2025. If I can take your lordship to the order first at page 73. Page 73, the relevant will be at page 78. 78, paragraph 4 and 5. Your lordship got, my lord?
So it has directed the appellate authority
My lord.
to furnish the information.
My lord, not that way, but it says that you take appropriate action, and appropriate action can be nothing but to give us the information, because, my lord, the State Information Commission relied upon a judgment by Jharkhand High Court. It's State of Jharkhand versus Naveen Kumar Sinha, and an SLP was filed, and that SLP, my lord, if I have understood, it was dismissed on merit. If your lordship can have the SLP, whether, my lord, what I have understood is correct, because SLP is not, it is dismissed with some referring to the facts of the case. My learned friend Mr. Vikas will be there if he has even. My lord, this was SLP was filed by State of Jharkhand. On top, your lordship will see Jharkhand versus Naveen Kumar Sinha. And the order says, in fact and circumstances of this case, we are not inclined to interfere with the impugned judgment.
Basically to provide information. The direction is basically to...
Petition is dismissed. So on the facts of this, it has become a binding precedent and provide information. Yes. My lord.
Who is Mr. B. Deka, State Standing Council, Assam Information Commission? Because I have already held. Who is Mr. Deka, Standing Council, Assam Information Commission? Mr. Have you served him a copy?
No, my lord.
There is a Standing Council.
No.
Because I have already held.
My lord.
In actually two judgments that Assam Information Commission,
My lord.
if its directions are not complied with,
My lord.
then it is not a teethless body.
My
It
lord.
has its own power of contempt
My
to
lord.
for compliance.
My lord.
I have already held in two judgments, Mr. D. Deka or B. Deka. D.
My lord.
Deka. D.
My lord.
Deka.
I understand, my lord. If your lordship can kindly look at page 79 for a second, my lord, because this is what disturbs us. Your lordship got me, lord.
Yes.
In view of the fact that a case in this regard is already under review at the Lokayukt Assam, Lokayukt has got nothing to do with this. And the observation made above, the Commission appears to have no reason to issue specific direction in the instant case and request the First Appellate Authority, Office of the Fire and Emergency Services Assam Headquarters, to take appropriate action on the basis of facts and observations mentioned above. So, my lord, there is no specific direction. This is what learned State Information Commission has
But
stated.
State of Jharkhand, that quoted paragraph,
Yes.
paragraph 26,
Yes,
it is
my lord.
clear the very purpose of the act will be frustrated.
Yes. my lord.
Moreover, disclosure of information sought for by the petitioner cannot and shall not be a trade secret or commercial confidence. Rather, disclosure of such information shall be in public interest,
Yes. my lord.
inasmuch as it will show the transparency in the activities of the government. That is where the SLP has been dismissed.
My lord.
So basically, it is disclosure of information.
Yes, ma'am. It
And
is.
Assam State Information Commission has apparently directed for disclosure of information
Yes.
to the
yes,
First Appellate Authority.
My lord. My lord.
And I have, after going through the provisions of the Right to Information Act,
My lord.
I have already held, because bunch of writ petitions started coming.
Yes, my lord.
So in that context, after analyzing the provisions, I have held that State Information Commission can secure compliance of the order in what manner?
Yes, my lord.
By punishing the appellate authority. So
It's
it is not a
provided.
teethless body.
Yeah, it's statutorily provided. Only because
Yes,
of
statutory.
that.
So it is,
Yes.
if for non-compliance, it has ample power to
Yes.
enforce its own order. I have already held. Otherwise, at one point of time, writ petitions started coming thick and fast.
My lord.
So can you serve a copy to Mr. Because I have
We will.
asked Judgments in two,
We will-
three
we will serve.
petitions.
We will serve today.
Mr. D. Decca. No, Mr. S.S. Roy? He is a standing counsel. So he'll be having the writ petition number.
My
Let me examine.
My lord.
Day after tomorrow?
My lord.
Day
My
after
lord.
tomorrow?
Can it be on?
Yes. Wednesday only?
No, no. My lord. My lord, can it be, my lord, tomorrow or day after tomorrow
try.
also?
We'll
Day
try.
after.
Okay, day after tomorrow. Heard Mr. D.K. Mishra, and senior counsel through the virtual mode, along with Mr.
B. Prashad.
B. Prashad, and counsel for the petitioner. Also heard Mr. Who is there for the state? B.J. Talukdar, and senior counsel, assisted by Mr. P.K. Methi, learned government advocate for the respondent number 134. Post of Mr. Prasad, learned counsel for the petitioner, shall furnish a copy of the writ petition along with annexer to Mr. B or D, Mr. S.S. Roy? D. Decca, learned standing counsel. Assam Information Commission, during the course of the day, released the case on Wednesday, reflecting the name of learned standing counsel, Assam Information Commission, in the respondent side in the call list.
My lord.
Also inquire with Mr. Decca, what is the writ petition?
Whether he is there, otherwise whoever is there.
May I please, your lordship? The petitioner before this honorable court, your lordship, for freezing of account, your lordship. The petitioner's bank account was froze by respondent number 3 in arbitrary on a dispute of amount of rupees, only 2,207 rupees, your lordship.
Any cyber complaint?
Yes, your lordship. One cyber complaint was raised by.
Why is that?
No acknowledgement receipt was there, annexure 3, your lordship.
Any cyber complaint? Where is that page?
Annexure 3, page number 10, your lordship.
10. You make this nodal officer, yes, state council. In case of bank frauds or this bank freezing, who is the nodal officer here? Please keep ready. No, give the full designation.
Lordship, I will give it. I will provide.
You file it, otherwise your case will be pending. Right?
Yes,
The nodal officer should be made a party who handles all these cyber complaint case, national what?
Lordship, I will.
National cyber something portal. He communicates with the
Yes, your lordship.
all these cyber complaint for the state of Assam.
Yes.
So he can provide information to the court. Otherwise, it will be difficult. There is a police
Case, yes.
So get the details from Mr. S.S. Roy. File an amended cost title so that Mr. Roy can get the information from the nodal officer. Otherwise, it will be very difficult.
In some of cases, your lordship, court already directs that only the disputed amount can be lying in the account and
That
amend-
can be, but it is the cyber portal,
Yes, your lordship.
bureau, which can give concrete information.
Yes, your lordship.
Heard, Mr.
A.
A. Hussain, learned counsel for the petitioner. Mr. S.S. Roy, learned government advocate, is to provide the details of the nodal officer for the state of Assam in respect of cyber complaints relating to bank freezing, bank account freezing, to the learned counsel for the petitioner during the course of the day. On receipt of the details, the learned counsel for the petitioner shall file an amended cost title for implement of the nodal officer concerned jurisdictional nodal officer. Release the case on Friday.
Obliged, your lordship.
No, এনেকে নহয় মাজতে।
Item 4. Lordship, will pass it over for the timing, Your Lordship. Number 5.
May I please, Your Lordship. My lord, in
Yes.
this case, my lord, admitted the land records have been misplaced from the Deputy Commissioner Office, my lord. And because of that, my lord, we have been reasonably apprehension that all land records has been misplaced. Similar case is also pending in this respect, my lord.
Yes, Mr. Henry.
Lordship. Lordship, notice be issued, Lordship. Notice issued. এই মোশন কিছু দেবো
The petitioners who are in evidence, who have stated that they are in evidence of village Chandipur grant, Roman 2. I have approached this court seeking direction to the, seeking inter alia direction to the respondent authorities to restore the land records like old Sita book volume 3 and draft Sita volume 3, as well as SOFA, SHOFA. What is SOFA? Again, a grand total of the Sita book for village Sandipur grant, Algapur, in the district of Hailakandi, on the ground that the respondent authorities have projected that the original Cheetah Volume 3 and draft Cheetah Volume 3 of village Chandipur grant, Algapur, is stated to be missing. The petitioner has also sought for a direction to the respondent authorities to enter their names in the newly constructed Sita and Jamabandi of Moja Sandipur ground, reconstructed as per order dated 6/3/2024, passed in IAC number 762/2024 in WPC number 3026/2029. Issue notice returnable on in 4 weeks. As okay, heard Mr. So-and-so for F.A. Loskar, petitioners. A. Authorised 1 and 2 revenue.
I'm for 3 to 7.
3 to 7. Issue notice so-and-so as Mr. Authorised has appeared accepted notice on behalf of 1 and 2, and Mr. Hendrik 3 to 7 formal notice dispensed with extra copy. You need to work in this one today. The respondents.
My lord, till returnable date, the petitioner shall not be evicted, my lord. Similar intending order is there, my lord. Your lordship's order, my lord. Page number 73, my lord.
Okay, page number 73. 7 and 8 paragraph.
Compliance, my lord.
6.
Very pleased. My lord, by this writ petition, my lord, we are challenging, my lord, demolition of building notice, my lord. All of a sudden issued, my lord, page 49, my lord. This was issued by the Sunari Municipal Board Chairman and countersigned by Executive Officer, without pointing out any deviation or alteration in the building, my lord. And I have constructed in the year 1998, my lord, as per the assessment made. I am also alleging some liability of the chairman, my lord. Yeah. May I read, my lord, page 49?
Yes, I have read.
Now, the A1.
What was the previous events?
My lord,
What are the previous events?
previous event, my lord, I have, as per the assignment, page 22, my lord. I have made constructed the building, my lord, page 22.
Paragraph, page 22.
My lord, type copy. As per the house plan and the assessment made, my lord, page 22, last portion, and page 23. These house tax are all been, my lord, they have already been confirmed by them. As per that, my lord, they have declared, we have paid, my lord, and we have constructed the in 1988. Now, my lord, in 23, my lord, I made some change of electrical wiring and tiles, my lord, and painting. Now, without making any inspection, my lord, the chairman, my lord, issuing, my lord, telling me to, my lord, demolish the entire building, my lord, 2-story, my lord. Which portion of deviation, alteration, nothing has been stated. And even his conduct, your lordship will see, both the chairman, my lord, he even,
It was said that you did not obtain any permission.
I have obtained, my lord, I have stated, my lord, page 52 also, my lord.
Where is your permission otherwise?
Otherwise, my lord, page 22, my lord. This was declared by them, my lord. As per the assessment they made, my lord, this. In the prescribed format.
This is tax assessment.
Yes, they used to make tax assessment, my lord. Sunari, my lord, municipal town committee at that point of time.
Basically, tax assessment, no
Tax
building
assessment,
permission.
my lord.
But after construction, the building tax has been assessed,
Tax assessment.
but no building permission, apparent.
Now.
Because there was a prior notice, page 35,
Prior notice, my lord.
page 35.
Yes, yes, lordship.
Now what
Prior
happened?
notice.
After that notice, what happened?
I replied page 36, my lord. One notice, your lordship will come to page 38, my lord. 15 December, that is relevant, my lord. The chairman had issued this notice, my lord, in 15 December 23, my lord. On against that, my lord, on the same day, he has not given any time to reply, my lord. He fixed it on the same day. Then we immediately on 18/3, page 40, my lord, we have mentioned that these things that the earlier site plan at your office authority has died.
Yes, Mr. Heard Mr. B. Borua,
One and
Senate
two.
Counsel for the petition. Mr. Hendrik, you accept notice on behalf of
1 and 2 lordships.
Mr. J. Hendrik, Land Junior Government Advocate for the respondent number 1 and 2. Close. Fair enough. You are a landowner, periodic patta?
Yes, my lord.
Okay, the petition has stated that he is the landowner of a plot of land measuring 1 katha 7 lessas, comma, covered by diagram number 607. And another plot of land, two plots of land measuring 1 katha 7 lessas in diagram number 607 and 3 lessas in diagram number 608 under periodic patta number 126 within bracket new, comma at Sonari town. At village Sonari town, Moja, Abhoypur, district Shibohagar, subject for wherein he constructed
District lordship Soraido.
Soraido, wherein he constructed a 2-storied RCC building. Full stop. In this petition, the petitioner stated that the respondent number 3 from the year 2023 onwards has been issuing a number of notices in a mala fide manner, directing demolition of the said two-storied RCC building without compliance of the provisions of principles of natural justice. Full stop. Recently, the respondent number 3 has issued a notice dated 22/5/2026, impugned in the present petition, whereby the petition has been asked to demolish the said two-storied RCC building within a period of 30 days. From 22/05/2026, on his own, purportedly in violation of the respondent number 3 has alleged that the RCC building, two-storied RCC building has been constructed on the subject plot, purportedly in violation of rule or section. Section 177 of the Assam Municipal Act 1956 as amended. First of it is the contention of the petitioner that after construction of the two-storied RCC building, the respondent Sonari Municipality Board had assessed the building for tax
Page 22.
in the year, which year?
1998.
1998. And the petitioner has been duly paying all the municipal dues to the respondent municipal board from time to time. As such, the impugned notice is valid and arbitrary. So issue notice, matter of require consideration, issue notice, returnable on so and so. As Mr. Khandik 1 and 2, the petition shall take steps for service of notice upon the respondent number 3 and 4 by speed post within 2 working days from today. Post of para, considering the fact that the two-storied RCC building constructed in the subject plot was duly assessed for tax by the respondent Punari Municipal Board in the year 1998. And on the said basis, the petition has been paying municipal taxes, municipal dues regularly, it is ordered, in the interim that dated 22/05/2026 shall remain suspended till the returnable date.
24th July. Item 7.
May it please your lordship. Your lordship, briefly, the petitioner's predecessors were tenants under the Chapar Coach Begila Zamindari estate and were issued Khatyan number 62, where their names were duly recorded.
Yes, Mr. Roy.
Lordship, earlier they have approached this court.
Hmm.
Kindly see the
Order.
on page 26, they have withdrawn the case. There as page 26. There are 13 petitioners at that petition, Lordship.
But
Now
Liberty,
on,
there was Liberty.
yes. Now
These, how many
petitioner number
petitioners
2.
here? How many petitioners here?
Here only one.
One.
So I have to
Fajal
open-
Pramanik, he was there.
Yes, he was there. Petitioner number 2 was there.
Yes.
Now, Lordship, let me have the instruction whether the others are not before your Lordship. Must they have got the settlement?
But there are other petitions. What is this? Page 29.
Page 20.
Shahjahan Ali.
This is a separate petition where Lordship here one order was annexed, Lordship. Petition notice, lordship.
Third, Mr.
I.S. Mazharbi, your lordship.
S. Major, learned counsel for the petitioner. A. Authorised, Revenue 1. S.S.
three.
Roy,
2 and
2 and
3.
3. The petitioner has stated that his predecessors were tenants under Chapar Coach Begila Jamindari Estate in the Astral district of Dhubri, and they were issued tenancy Khatian number 62, covering an area of 34 bighas, 2 kathas, 16 lessons of land, where they constructed their dwelling houses and were cultivating the remaining part of the land. The estate was subsequently acquired under the Assam State Acquisition of Zamindari Act 1951. But the petitioner and their predecessors remain in occupation of the said land till date. It is the contention of the petitioner that by operation of law under Assam land holding within bracket adoption of relationship under the Assam Land and Revenue Regulation 1886 in the acquired permanently settled estates within bracket close Act 1974, the petitioners and their predecessors got the status of landholders, but the land patras have not been issued to them. The petitioner has stated that though the petitioner submitted an application under Mission Bosundara, but the same said application was not considered post of apprehending eviction. The petitioner has preferred the instant read petition. Mr. So-and-so, learned counsel for the petition has submitted that in similar matters, in respect of read petitions prepared by similarly situated read petitioners, notices have been issued and an interim order for they are protected. They have been protected by an interim order of maintaining status quo. Post of issue notice returnable on so and so as Mr. Aforesaid, respond number 1, and Roy 2 and 3. No formal notice. As as interim relief has been extended to the similarly situated read petitioners. It is provided in the interim. And it is submitted that petitioner is in possession of the parcel of land under earlier tenancy Khatian number 62 till date. It is provided in the interim that status quo as regards such possession shall be maintained till the returnable date.
2407. Item 11. Item number 11.
There is no representation on behalf of the petition today on call. Mr. R.V. Goswami, learned counsel. You are preparing for? On behalf of Ms. MD Bora, Land Standing Council, Corporation Department. He is in attendance. In view of non-representation, let the case be listed. May date in the next week.
Supplementary list, item 47.
Kindly take it up after some time.
Item number 48.
Any check. Yes,
Lordship, in this case, Lordship, I have 7 simple letter dated 6/6/2026, annexure L, page number 52. May I please read this letter?
National Highway,
50-meter distance from
Huh?
National Highway. Your Lordship.
National Highway.
Yes, Your Lordship. 50-meter distance. Prior to this notice, Lordship, one another letter has been issued by the municipal authority. And being agreed the said letter, Lordship, previous occasion we have filed it petition.
This is, it says that you are in occupation of land reserved for National Highway.
No, 50-meter distance, Lordship. Prior to this letter, Lordship, one another letter has been issued earlier occasion, Lordship, by the municipality board, Lordship. And being agreed the said letter, Lordship, we have filed writ petition. Honorable High Court directed order dated 29/4/2024, Your Lordship, annexure J, page number 46, Lordship. Coordinate.
Just a minute,
Honorable High Court order, kindly be very.
just a minute, sir. Yes, Mr. Aforesaid, in what capacity he has issued this notice?
He could not.
Huh?
He cannot, my lord.
Find out about his authority.
My lord.
He says in a vernacular that petitioner has constructed a shop
Over national highway.
unauthorizedly
Yes.
in on land reserved for National Highway 15.
Right.
So this issue can be taken up only under the control of National Highways Land and Traffic Act 2002. There has to be a highway administrator. He may be in the capacity of highway administrator. I don't know. If he is, he has to be authorized by central government.
Yes.
And he says Onoita Assam Land and Revenue Regulation. These are contradictory.
Mixing up things.
Huh?
Mixing up things, my lord.
Mixing up things. If he says land reserved for NH 15, then it will be under that act. And he will be under as a highway administrator.
Yes.
But if it is government land, then Assam Land and Revenue Regulation.
Then
Right.
18(2) and all those.
So if land already reserved for national highway, it means it is vested in the central government.
Central government.
So highway administrator has to act.
Yes.
Whether he has been vested with a power.
That we have to ascertain.
Can you
Apparently
ascertain?
not. Apparently not, but we will get the instruction.
Right.
Right.
Get the instruction. No point keeping it pending.
Right.
You get the instruction by Friday. If he acts as a high, then also he has to issue clarifying his role as a highway administrator. Right. If the land is reserved for national highway, land belongs to central government. As per the national highway.
Lord, so may kindly record that part.
Huh?
That will be better for me to communicate.
It is better for you, right? You right?
Right.
I have indicated to you. I'll say in what capacity.
Right.
Whether under the National Highway Act, that act, or under the Assam Land and
Land and
Revenue
Revenue
Regulation, settlement rules. Right?
Right.
Because this is vague. Heard Mr. M. Shoikal, Learned Counsel for the petitioner. And Mr. A. Aforesaid, Learned Planning Council, Revenue Department for respondent number 1. Yes, Mr. Hazarika, have you understood?
I have also pending stuff.
And who is for municipal administration? H.K. Hazarika, Learned Additional Senior Government Advocate. You are Additional Senior Government Advocate? Junior Government Advocate. Assam for the respondent number 2, 3, and 4. And 6. Post of para. The petition has been served with a notice dated 6/6/2026 by the respondent number 4, whereby it has been informed that the petitioner is found constructing a shop on a plot of land reserved for National Highway 15 on a plot of land located in Moja, Lakhimpur. North Lakhimpur Revenue Cycle. On a plot of land located in so and so. Unauthorizedly. And stating that the said plot of land is reserved for National Highway 15. The petitioner has been asked to remove the shop purportedly constructed in an unauthorized manner from the said plot of land within a period of 7 days from the receipt of the notice dated 6/6/2026. Post of. The notice has further informed that in the event of failure on the part of the petitioner to remove the shop, eviction process will be undertaken as per the settlement rules framed under the Assam Land and Revenue Regulation 1886. Within bracket the regulation 1886. Full stop. Para if the Learned State Council, Mr. Bhattacharya and Mr. Hazarika shall obtain instruction whether the plot of land in respect of which the notice has been issued is a plot of land reserved in the central government under the National Highways Act, or it is a government plot of land. Full stop. The London State Council shall also obtain instruction in what capacity the respondent court has issued the impugned notice dated 6/6/2026. That is, comma, under the provisions of the as a highway administration under the control of National Highways within bracket Land and Traffic bracket close Act 2002, or as an officer of the, what is the provision, or in the capacity some land and revenue regulation, or in exercise of the powers
Under settlement rules.
নতুন fund, green, in exercise of the powers, green, under Rule 18 of the settlement rules framed under the Regulation 1886. And Mr. PROCEEDINGS and Mr. Hazarika have sought for a week's time to obtain the necessary instruction. To start. Release the case on next Monday.
Tuesday, can it be on Tuesday?
Okay. Till then, the respondent authorities, more particularly the respondent of shall not take any further steps in terms of the impugned notice dated 6/6/2026. Mr. Soikia Learned Counsel, the petitioner shall furnish a copy of the writ petition along with annexure each to Mr. Authorised and Mr. Hazarika during the course of the day for enabling them to obtain the necessary instructions.
Of like 23rd.
Find out what is capacity.
Yes.
It cannot go, two things cannot be mixed.
Yes. Of like
2306. Time being matters. Item 1.
Manad, I am sorry that I was stuck in the traffic jam. Manad, this application is filed under section 10, Manad, of the Contempt of Courts Act. Because Manad, I lost an affair because I wanted to purchase, I am deal with animal foods. I wanted to purchase some cattle feeds from the FCA of Benares. So Manad, somebody.
No, tell me how it comes under section 10.
Manad, page 34, Manad. First of all, Manad, page 34. Direction was given to the bank to defreeze my bank account.
No, okay. What is the order of the last few orders of the trial
Last
court?
order is at page 80, your lordship will find, last paragraph of the trial court, page 80. May I read it slowly? On perusal of the case record, I found the submission of learned counsel appearing for the petitioner, such and such to be true. It appears that till date, AU Finance, Small Finance Bank has failed to comply with any of the aforesaid orders of the Honorable Apex Court. It is to be noted the case is of the year 24, and due to the negligent approach of the AU Small Finance Bank, the petitioner is suffering a lot. Such conduct of the AU Finance Bank is not acceptable at all, and it amounts to contempt of the court. There were a lot of direction, even the High Court has said to give it, but
That the case has been disposed of.
my lord, because not disposed of, it is still pending.
It is still pending. They have taken that direction has been directed to comply with the orders of the Honorable Apex Court, I don't know.
Page
Honorable-
34, page 34, that
No.
is there. Sundar
No.
Bhai Ambala's judgment was there.
No, it has said, considering the mitigating reasons as discussed above, AU Small Finance Bank is strictly directed to comply with the orders of the Honorable Apex Court. Apex Court?
Sundar Bhai, because they are saying about Sundar Bhai Ambala, madam. Page 34.
Okay, and directed to monitor whether AU Small Finance Bank is complying with the orders of this court or not. Send a copy of this order to Superintendent of Police for information.
This has been done.
Send a copy to the order to the OC in charge for information and necessary action. Right. Court has held that it amounts to contempt of the court. Now, whether it has already issued a direction.
But as per the section 10, it is only the High Court can look into the matter, but not the trial courts. It amounts to, but the contempt notice can only be issued under section 10, my lord, that High Court will act as a, if I can read it slowly, my lord. Every High Court shall have and exercise the same jurisdiction, powers and authority in accordance with the same procedure and practice in respect of the contempt of court subordinate to it, as it has an exercise in respect of the contempt of itself.
Item number 2. Item note. What Mr. P.K. Roychuri, Learned Senior Counsel, state by Ms. R. Learned Counsel for the petitioner. Post of Mr. Roychuri has submitted that in the order dated 21/5/2026. Within bracket annexer 18. Passed by the learned Chief Judicial Magistrate Kasha Silsor in Silsor Police Station case number 366 of 2024. The learned court has observed that the conduct of the AU Small Finance Bank has amounted to contempt of the court. Full stop. Meaning thereby, the respondents who were in charge of the day-to-day, who were responsible in the conduct of affairs in the concerned bank, i.e. AU Small Finance Bank Act, comes under the purview of Section 10 of the Contempt of Courts Act 1971, and they are liable. They are under issue notice, returnable in 4 weeks. Tips. Have you brought this order to the notice of the?
But everybody.
Where is that? No.
Their counsel is appearing.
No, counsel is appearing is a different thing.
But they were brought to the notice.
No. Where is that?
My lord, your lordship.
Where is that?
Your lordship will find.
No, not there.
Your lordship will look into the earlier orders.
No. That you are going to initiate a contempt proceeding before the High Court. Have you brought it to the notice of the court?
After this order, it was passed by the trial court.
Maybe it is an inter-party order.
Well, inter-party order.
But before initiation of contempt proceeding, it must be brought to the notice of the court, the contemptor. That is the procedure.
That has not been done, but the inter-party.
Otherwise, we don't issue notice. That is why when I started to say it is averred.
But
it is averred in so and so.
Writing an application, we have not done so, but it is of inter-party.
It is to be brought to the notice. Otherwise,
but the bank
contempt initiation of contempt proceeding is not a
easy matter.
Not an easy matter, sir.
Correct that definitely.
For that effect, we always make I always make a make it clear that it has been duly brought to the notice of the LA's contender
But that,
on so and so.
may I abide by your lordship's order, but only thing that I can know, say that all the parties were present in the court and they.
No, that is not. That your initiation, first you have to bring it to the notice of the authority.
So your lordship may give an observation that we will file an application before they
We'll close this, then we'll allow you.
allow me to file an application.
As it transpires that the copy of the order dated 21/5/2026 has not been brought to the notice of the LA's contender, and that the petitioners contemplated action to bring the action to initiate proceeding under section 10 of the Contempt of Courts Act 1971 are not brought to the notice of the court, comma, this contempt petition, comma, is closed by granting a liberty to the petitioner to initiate, to bring the order dated so and so to the notice of the LS contender along with the contemplated action to be initiated by the petitioner under section 10 of the Contempt of Courts Act 1971. At first, the petitioner is granted liberty to file the contempt petition afresh thereafter.
If not complied, well,
If the order is not complied, that may
solve
give you
that problem.
easy access for compliance.
Obliged.
4.
Worship, on June 2025, we made a complaint regarding illegal construction of a wall. Thereafter, both the parties were heard by GMDA. An order was passed that it was an unauthorized construction and for demolition. Thereafter, GMDA issued orders for demolition on 2 occasions, but it was not complied with. We came before the Honorable High Court. But you would find an order at page 42.
Yes.
43, Lordship, at para 3. Upon the matter taken up as Bora the Learned Counsel appearing on behalf of GMDA submitted that GMDA has not taken any steps at present on account of the Assam State Legislative Election 2000 as well as implementation of the Model Code of Conduct. He further submitted that after the Model Code of Conduct is over, steps would be taken up by the GMDA. In that regard, he has placed before the court.
Where is Mr. Bora?
He was here. He was just here.
Let him come.
Yes.
Supplementary list, item 47.
Still on deck, my lord. Mr. Chaudhary will appear. my lord.
Then
Still on deck.
Wednesday. Okay, on the prayer, Mr.
SS Ahmed, my lord.
Lays the case on Wednesday.
My lord, it is a matter relating to eviction, my lord.
Wednesday.
No, Lordship, eviction letter was issued in the year of 2020.
My lord, apprehension is there. my
After
lord.
Nothing will happen Wednesday.
Yes, sir.
Second time, sir.
My lord, at 2, my lord. if possible.
Next.
Daily list for admission, item 13.
May his lordship. My lord, here the petitioners are praying for ex gratia on the death of the husband of the petitioner number 1, my lord.
Yes, who saw time last time?
My lord, the private respondent.
Private respondent, my lord.
M. Sharma. Who is he?
He represents respondent number
10.
10. Private respondent.
It is electrocution.
My lord.
In what capacity? Respondent number 10, respondent
My
number
lord,
seems to be a
the
private
on
party.
the affidavit filed by the railway, the
Mhm.
private respondent will implement it, my lord.
How many amended costal? RS infra projects. Yes, in what capacity respondent number 10 is involved?
My lord, here,
My lord, what had happened is that there's my lord may look in the electrical inspector report that is filed by the affidavit in opposition to, my lord, by the state.
Page, running page.
My lord, the running page
Affidavit. He is respondent number
2, my lord,
2.
of the state, my lord.
41.
My lord may get it at annexure A is a report, my lord.
Okay.
So the brief description is here. From the documents furnished by the concerned officials of APDCL and the information gathered from witness and after spot verification, it appears that on 21st July 2021, the victim, who was a painter, came in contact with bare overhead live 11 kV line while trying to paint a railway high gate near Ohomia Proceeding Office at Manmoni Rise of Goswami Road, Chandmari, Gauhati. Got electrocuted and died on spot around 7:30 a.m. It is pertinent to mention herein the said 11 kV line is well above the railway high gate. The gap between a live bare overhead and a railway high gate is maintained by APDCL, which is almost 8.5 meters on the ground level. It is further mentioned that no prior information regarding painting work to be done by the railway authority or its contractor was communicated to the concerned supply, that is APDCL. From the fact leading to the accident. From the fact and the finding, it is opinion that the painting work had been done in a dangerous proximity without any prior intimation to the concerned authority of APDCL for shutdown of 11 kV overhead line caused a fatal accident. Had appropriate shutdown been taken of the said live bare overhead line by the concerned authority of Railway Highgate, the instant electrical accident resulting the death of victim would not have been taken place. Contravention from the fact and circumstances leading to the accident appears that is contravention of regulation on part of the victim. Recommendation: the safety provision of the CARC should be strictly complied with the concerned authority. It is suggested while executing any work under overhead line, prior permission from the owner or supplier of the overhead line shall be taken. So, my lord, thereafter the APDCL was not liable. So it is the railway, and because this lines, it's electrical lines from which this electrical trains basically travel. So it is maintained by the railway. Only the line is supplied by the APDCL. So that is why, my lord, by the previous orders of this honorable court, the railway was made party and the contractor was also made party because it is their direction. So it is them who has to.
So respondent number 10.
Yes.
He is supposed to give details whether he is the disease was a man employed by him.
Yes, my lord.
And whether he is a contractor under the railway.
Yes.
That is the purpose.
Yes, that is the purpose. Absolutely.
For that purpose.
Yes, my lord. And whether he had taken intimation.
That purpose.
Yes.
Okay, where is Mr. M. Sharma? There are many M. Sharmas. Which M. Sharma is this? Madam, which M. Sharma? Last time he short time. M. Sharma. And this respondent number 10 is newly implemented.
Yes, madam. Then on the last occasion in May, they have taken time to file affidavit.
We fixed it today.
Yes.
Name is reflected or not? Who name someone? Colonel Mohan Saab.
Reflected, ma'am.
When the date occurred? In the year 2021?
Yes, 21st July 2021, my lord.
Colonel Mohan Saab. T. Wapangla. Petitioner. RDB 1 and 8. SP Sharma. Standing on slave PDCL 2 and 3. Who is respondent number 6? Madam, your name? R. Khatun. On behalf of Mr. N for Nagaon. M for Meghalaya. Okay, M. Bora. Learning Council for the respondent number 6. And Mr. S. Roy. Learned Junior Government Advocate for the respondent number 4 and 7 are present. Mr. M. Sharma, Learned Counsel for the respondent number 10, who sought time and was granted, who sought time and was granted 2 weeks time to file an affidavit on behalf of the respondent number 10 is found absent today on call post of on the as his name is reflected in the call list, comma, another 3 weeks time is granted, comma, as the last opportunity. Yes, we have made labor for your absence for last 5 minutes.
Sorry, Your Lordship, I know next before
Yes.
number 1.
You're supposed to file an affidavit.
Yes, Your Lordship, 1 week may be given because we have received the data was just to file it.
Okay, Mr. Sharma has sought for another week's time to file the affidavit in opposition on behalf of the respondent number 10. The prayer is allowed, release the case also.
One I 47 item, not now, 2 if possible.
I don't take it 2.
My, I'm obliged to most. I'm sorry, my friend.
Wednesday, tomorrow.
Tomorrow. Item 47.
14. Item 14.
Yes.
My lord,
File affidavit in opposition.
my lord, the same issue has already been decided, my lord, by coordinate bands in sensory ply, my lord. But then obviously they have filed an appeal. Probably that is the reason why they will seek time, my lord.
That is pending adjudication for the division bench lordship, and we were under the impression that they will be seeking time for filing the affidavit in opposition.
No, issues are otherwise clearly covered, my lord.
It has been decided. Decided against the petitioner.
Against the petition.
Any stay order
Currently,
before the division bench.
No.
Currently, there is no stay order.
So what to do?
Lordship,
No stay order, otherwise
my lord.
Lordship, if
mere pendency before a larger bench may not stop. That is one proposition. Sometimes division bench is in season of the matter. The single bench should wait. Which one is to be preferred? We are in also dilemma.
Lordship, if the respondent authorities want the court to hear the matter, then
Mr. Pathak is not inclined to file any affidavit.
My lord.
then a date can be fixed, Lordship.
The issues are, my lord.
That can be taken.
Issues
No,
are
no,
already
I have
dealt
not
with,
seen. I have seen the only last order. What
My
is
lord.
there inside the brief? I have not seen.
my lord.
What to do? Tell me.
Let
In
us
that case,
await the DB order. my lord.
Okay, heard Mr.
No, no.
B. Sharma, Lordship.
B. Sharma, learned counsel for the petitioner, Mr. B. Pathak, learned counsel for the respondent number 4. And Mr. Gugoi, you were there.
120 or so.
Central Government Council for the respondent number 1, 2, and 3. Post of. As the learned counsel for the parties have submitted that, the issue is presently before the division bench. In writ appeal number,
My lord, writ appeal has probably not been numbered. There was some delay, only the delay has been confirmed.
okay, is presently before the division bench. And so let the instant case be listed after 6 awaiting the outcome of the writ appeal pending before the division bench. Due to above submission, let the case be listed on Swens.
12th August.
Obliged.
Item 15.
Hearing for so and so, doing the matter is on. Yes, madam. Orderly. Why it was recorded by the court that no eviction drive was carried out? Suddenly on so and so. Okay. Where is the land counsel for the petitioner?
In the last occasion, my lord, learned counsel was not present also.
No, no, last occasion it was present. She was.
But some other person was advocate as attend.
Because this court
Writ petitioner filed a
right.
petition. My lord, another title suit is pending before the civil judge junior division in respect of the same relief.
There is no representation on behalf of the petitioner today on call. Hard miss revenue.
I am for respondent number 6.
Who is for the petitioner? Mr. B.J. Thaludar, Senior Counsel, assisted by Mr. P.K. Mehdi, learned Government Counsel for the respondent number 1 and 2, Ms. P. Thapa, learned counsel on behalf of Mr. S. Doctor, learned Standing Counsel, Panchayat and Rural Development Department for the respondent number 3. 1, 2, and 4. Anybody for 5? And Mr. I. Taludar, learned counsel for the respondent number 6. Full stop. 23/10/2024, fourth paragraph, the case of the petitioner is that. Absolutely. In paragraph 6 of the writ petition, the petitioners have averred as under court corrigible. In the affidavit in opposition, filed by the respondent number 4, the respondent number 4 has stated as under. Paragraph 3, 4, and 5. Paragraph from the above, comma. You have filed any affidavit? Mr. What did you say? The tender notice,
there is no prayer by the writ petitioner against the respondent number 6.
No, the tender notice.
In respect of tender notice, it is for a period of 1 year. It is already left 2 years before.
Okay. Respondent number 6.
Yes.
2 to 36. Where have you stated?
My lord, it is
Okay. As from the above facts, there appears to be no cause of action to proceed further with the writ petition. However, as a learned counsel for the petition is found absent today on call, I'll lease the case to come up for instant justice again on Wednesday. In the event none appears for the petition on the day, the petition will be dismissed for non-prosecution. Wednesday, we'll dismiss that.
Item 16.
May it please the Lordship. Lordship, we are filing our affidavit today, Lordship, during the course of the day.
Lord, that is okay. But my lord, what I'll pray for today, my lord, because a copy has been served upon us. My lord, new jurisprudences are being, my lord, evolved. Forensic Directorate nowadays, my lord, compares signature based on photocopy. Well, I'm shocked. My lord, it's a my lord scam which is going on in Karbi Anglong district. My lord, what had happened? The petitioner, she lost her husband, she lost 2 of her sons. Now, my lord, this particular tea state was purchased by the petitioner's husband from Hanuman Tea Company. Now, my lord, when I apply for mutation, they're denying mutation on the ground that the signatures are not tallying. My lord, the Hanuman Tea Company's director has not come before any authority to say that we have not sold this garden to us. My lord, the chief executive of the Karbi Anglong District Council is involved in this case, my lord. Already a part of the money which was received as compensation has been received by him. And my lord, on one pretext or the other, they are just delaying the matter. Now, therefore, my lord, what I'm praying for is, let them produce the record as to who objected. I am an authority, my lord. Somebody must come before me and say this is not
you get the records also.
Yes. Let the matter be fixed on a particular date. We'll also file a reply, my lord. And I think, my lord, time has come to expose all these authorities, my lord. I'm shocked. Kindly see, my lord. Please enclose purported Sanjay Paraman is one Xerox sheet. And they're comparing it. Nobody has taken, my lord, specimen signature of anybody.
Okay.
So, my lord, let them produce the record which led to the sending of this document to the, my lord, Forensic Directorate.
Heard, Mr. K. Churi, Learned Senior Counsel, stated by Mr. For the petitioner. Petition. Revenue and Bordeaux Standing Council Revenue 1. Who is for K.S. Camprai, Learned Standing Council
2, 3, and 4.
KAAC for the respondent number 2, 3, 4. Mr. DJ Talutar, Learned Senior Counsel, stated by Mr. P.K. Mehdi, Learned Government Advocate for the respondent number 5. Mr. C. Burua, Learned Standing Counsel, NHAI for the respondent number 6. Who is for 7?
Lordship, I am present.
Mr. R.K. Talukdar, Learned Standing Counsel, NHI DCL for the respondent number 7. 8, 9, 10, 11.
I'm for the 10.
Mr. G. Jalan,
10 kun hai?
Learned Counsel for the respondent number
Hanuman. Oh.
10. Who is for 8, 10, and 11? 12. Okay. Miss
8
Camprai,
to 2 Jalan.
Learned Counsel
Hanuman.
for the Learned Standing Counsel, KAAC. For the respondent number 2, 3, and 4 has submitted that the counter affidavit on behalf of the respondent KAAC authorities is going to be filed during the course of the day. Post of Mr. Chaudhary, Learned Senior Counsel, appearing for the petitioner, has submitted that the respondent KAAC authorities have in the meantime sought opinion of the Forensic Science Laboratory as regards signatures of certain individuals related to the subject matter on the basis of photocopies. And an explanation from the respondent KAAC authorities is necessary to find out the region for sending
Yes.
such photocopies for forensic opinion. That is their submission. Only records.
My lord.
The records, not the whole record.
My lord, we have filed the affidavit
Yes,
annexing the, my lord, Director of Forensic Science, my lord, report. On the basis of, my lord, there is search sheet has already been filed against the petitioner. Criminal case is pending, my lord, for finding the, my lord, forged document, my lord.
Let us have the,
My lord.
Yes,
my lord.
yes.
just a view of.
Everybody should go to jail.
Another point, my lord, another point is that, my lord, when the appeal is pending against the rejection of order of mutation, appeal is pending before the secretary. They have not taken steps to rectify the defects of the appeal. We have stated in the affidavit.
The list the case on so and so after vacation. The petitioner shall in the meantime file its affidavit in reply if so advised. The Land Standing Council AAC shall obtain the records related to the subject matter shall keep the record related to subject matter in his possession on the next date of listing.
Yes.
2807. Daily list, item 17.
The respondent revenue has not filed the affidavit.
May I plead your lordship? Lordship, we are directed to file our affidavit, your lordship. Lordship, affidavit prepared, stand for vetting. There is some correction in the affidavit. We are going to file within 2 days, your lordship.
Some urgency is there, madam.
Within 2 days.
You are having interim order.
But in spite of interim, my lord, they are, my lord, encroaching, and I have mentioned in my reply also, my lord. They are developing
Mr.
that.
B. Borwal and counterpart of petitioner is present. Ms. R.M. Das, Land Standing Council. NC Autonomous Council for the respondent one has submitted that affidavit will be filed, affidavit in opposition of the respondent NC Autonomous Council. Respondent council will be filed within a week's time. Full stop. He has just sought for listing of the case after filing of the affidavit. List the case after vacation. Interim order passed earlier shall continue. Till the next week.
Item 18.
Sir, I have request, madam. I have filed one affidavit on 12th, my lord. I think that is not on record.
Not on record.
Not on record. Can it be taken up any day, my lord?
My lord, the record, my lord, the petitioner case is that, my lord, the regarding the disqualification of the member, my lord, or ward member of Senate, a number of cases will dispose of, and the appeal also dismiss of. So, my lord.
Disqualified on what ground?
My lord, regarding the petitioner approached this honorable court for this disqualification of the member, the ward member, whether the regarding the child marriage, regarding, my lord, is and, my lord, the more than 3 children, that ground, my lord, the irrigation qualification, disqualification of the member, what member, my lord?
He is what?
He is a defected candidate, my lord.
Defeated candidate.
Yes, my lord. And a number of cases dispose of. and
Defeated
the appeal also
candidate,
dispose
for
of.
defeated candidate, it is election petition.
Yes, my lord. On that ground, my lord.
For
it is disposed of.
elector, it can be writ petition.
I understand, my lord. My case is little bit different because the cases.
Okay, then, in fact, this MK Mishra, learned counsel for the petitioner. Who is for the respondent, Mr. J. Hendrick, learned junior government advocate, for the respondent number 1 and 3, Mr. H. Amit, learned counsel for the respondent number 5. Mr. Mishra submitted that the affidavit in reply filed by the petitioner is not on record. Has been filed, is not on the record, and the case be listed on another date along with the affidavit in reply on record. Okay, list the case registered to find out the affidavit in reply, comma, stated to have been filed by the petitioner, comma, and to list the case along with the affidavit in reply on so and so. After vacation? After vacation.
2007. 20.
My lord, the matter relates to acquisition of land that the National Highway Authority Act Now, my lord, the case which we have projected is, my lord, part of the compensation has been paid and some amount is due. But most important is, my lord, award has not been given to us, neither it has been published. So in the absence of the award, my lord, we have.
Under which act? 2013 Act.
No, my lord, it will be actually, they will follow while calculating the, my lord, compensation, they will have due regard to 2013 Act. But the acquisition was under National Highway.
Okay.
Highways Act 1956.
Now
Here,
it
my
is.
lord, unlike in the 13 Act, where there is a provision of reference under section 64, here, my lord, there is a provision for arbitration. Now, because the award has not been published
So
officially.
3G1 record.
Yes.
3G1 award.
Yes, my lord, that is published, that is annexed in the affidavit number.
No, that is not the award.
Yes, that is the award. That is the
3G.
only. Yes, my lord. And if they have anything to say, my lord, they can challenge the provision of the law, my lord. As per the law, that has been calculated and finally that has been passed, my lord. And which they have referred to, my lord, Annexure 3A, my lord.
Well, lord,
That is the
perhaps they are
preliminary.
referring to page 43, my lord. This is not award, my lord.
Page 40.
Perhaps my learned friend is referring to page 43 of their affidavit. Sanction is hereby accorded for an amount of rupees 2 crore 16 lakhs. Only
Page
for making
43.
payment to the following partners individual being.
Page 43.
Yes, of the affidavit.
That is the sanction amount, amount sanction, that is the order passed. My lord, that is Annexure B, page 50, my lord.
50.
Yes.
50.
50 দেখুন নাই আমার।
9.
কি কি ও একটু কম।
As per their prayer before this honorable court, as regards the, my lord, the earlier, that is award, my lord, I talked to the authorities concerned. They could not provide any other, my lord, award as they claim, my lord.
No, my lord, that is not the answer. That could be their understanding. But there has to be an award.
No,
An
this
award has
is
to be
the-
published.
Is there any rules?
My lord?
3G1 says.
Yes, my lord.
Where any land is acquired under this act, there shall be paid an amount which shall be determined by an order of the competent authority.
Yes, my lord.
3G1.
Ah.
And 3G5. If the
3G
amount determined by the competent authority under subsection 1 is not acceptable to either of the parties,
Yes.
the amount shall, on an application by either of the parties, be determined by the arbitrator to be appointed by the central government.
Yes.
Now, is there any rules that there has to be under 2013 rules? There is a specific form under the Assam RFCT LARR rules 2015. That this is the form in form number so and so.
Award is always followed by gazette notification. Normally.
No, is there any rules framed under this NH Act?
Whether, my lord, rule making power is there, let us see, my
Central
lord.
government has.
Oh, there is a rule. There is a rule.
Central government power is there, I think. Definitely, central government will have power. National highway rules. Because both the 1984 rules, 1894 rules and 2013 rules are there, where award has to be in a specific form.
Yes.
But here it is there.
Lord, that aspect, let me check, my lord.
Because here it says the amount determined by the competent authority.
Yes.
No,
lordship is correct, my lord. There is some.
And most
confusion.
important part is,
and
my lord,
unlike I think 1894 Act or 2013 Act, there is no specific time limit for challenging the amount under
No,
3G.
under 13 Act, it is there, my lord.
Huh?
Under 2013.
Time limit is there. Here I have not found.
Here no time.
But that issue has not been raised before me, so I have not looked into it.
Right.
If there is any, otherwise,
3G
if we go by arbitration and conciliation rule, then there are some time limits. Whether that bar will invite here, will be invited
That is
here.
another aspect.
If
Perhaps-
there is no time limit, then I can observe that you have the liberty to file.
Yes, yes.
So, but I have to be sure for, and Mr. Chaudhary has to apprise.
Lord, Lordship will have it on another day. I'll apply my
If no
mind
time
to this.
limit, then I can give you liberty to
Yes.
challenge it under
Yes.
3G5 before
Yes.
the arbitrator.
Yes, yes, yes. Let me go through it.
Just find out, Mr. Kolita, is there any rules specifying that in what form the award is to be passed by the Kala? And is there any time limit?
Yes, yes.
If there is time limit, then we'll try to observe, take recourse under section 14 of the Limitation Act, and
Right, right.
so that option will be available to
Yes, yes, yes. Milord can have it on next Monday, Milord.
you. Okay.
Lordship, yeah, in this petition, the issue is Lordship regarding page 25. They have issued a letter.
Anyway,
That is
next
the,
Monday,
that is the
Lordship.
preliminary stage, that we have admitted that, my lord. That is the amount, my lord, and after all, everything, taking into account all aspects of the
So
matter.
if
that
there
has
is
been
any
calculated.
specific form for passing the award
Whether-
under the rules,
And whether
then
there is
if
any
it is
time
there-
frame for approaching the arbitration.
any time limit. If there is specific form, I can direct Mr. Goswami to hand it over, and period
Prima
if
facie 3G5 doesn't indicate any
does
time.
not indicate. That is why. But
Whether in that view of the matter, the prescription in Arbitration Act will apply.
yes, but otherwise 2013 Act, there is a specific time limit.
Yes, yes.
If you
60
cross
section
that,
64 it is.
if
there.
you cross, then the Supreme Court has held
No,
no reference. That is why I am.
I think section 14 of Limitation Act may also come handy, Milord, in a given situation.
Section 14, yes. Section
That-
14,
That is regarding, Milord, condonation.
not condonation, exclusion of time period
Exclusion of time.
for preferring this writ petition,
Exclusion of time, correct.
not condonation. Condonation is very
Exclusion
strict.
is to be given by the legislature.
Legislature. But court has evolved. 14 can be
Yes.
applied somewhere in some city. Heard Mr. K. N. Chaudhary, Learned Senior Counsel, assisted by Mr. J. Kolita, Learned Counsel for the petition. Mr. R. K. Talukdar. He is not there. Who is for central government? Okay. Mr. D. Goswami, Learned Additional Advocate General. Assam, listed by Mr. P.K. R. Kapoor. P. Kapoor, and counsel for the respondent number 325. Okay. Yes, sort for whether learned counsel for the parties, list the case on Monday.
Milord, I think my learned friends some difficulty on 24th.
2406. Item 21.
H.L. Oscar, H. Sharma, Fazal Bhuya. Has been in fact. Yes,
As per my instruction, it was not infructuous, my lord.
My lord, that I received my parawise comment, lordships. In the parawise comment, it is stated that, my lord, that demarcation was done on 8/1/2026.
any report?
No report, my lord, that one report is there. Lordship, may kindly pay.
Just.
Obvious, no.
Initiated, my lord.
My lord, initially he was, my lord, submitted two application, my lord, where there is no doubt has been mentioned in the, my lord, that application. Last page, lordship. The petitioner and the second party, they are also present during that time, lordship. Oh, okay, okay. No, 6, 7. Eternal zero. Yes, it is done.
It was not done, my lord. Officials have visited the site and measurement was taken, my lord, and parties are instructed to wait for further order of the High Court, my lord. So it is was not done, my lord, till date, my lord. Only measurement was taken, my lord.
Hence, in presence of both the first party and the second party, boundaries of land under DAG number 212 have been properly demarcated on the ground.
Yes, my lord, and instructed them, my lord, to wait for the further order of the High Court, my lord.
What order is required?
Worship,
And it is found that there were earlier agreements also, let it be there. But
no pillar was installed, my lord, till
Mr.
date, my lord.
Loskar,
Worship. Worship, no pillar was installed till date, my lord.
where is LR staff report, Mr. Andy?
Lordship.
LR staff report. See, don't take this unauthorized occupation matter to the High Court. If the respondent number 4 has unauthorizedly occupied a part of your land, it is not a matter to be adjudicated in a writ petition. Right? For that, you have to approach the civil court.
Lordship, here.
Right here, where is the LR staff report, Mr.?
Lordship,
If last page is the LR staff report.
Lordships. LR staff report.
Okay, we can direct
Lordship.
install the boundary marks.
Yes.
In terms of the report, but there shall not be disturbance, anything with regard to the possession.
Yes, sir. Lord.
Mr. Borge,
Yes,
there shall not be only boundary marks are to be installed as per the demarcation process, but there shall not be any action. Parties will maintain their respective position with regard to possession. If anything is encroached according to the petitioner, he has to approach the civil court.
It is up to them, my lord.
It is
But
up to
upon
them.
my inspection, after the High Court have been written and it had to be addressed to the circle officer.
So far, we
Circle
have
officer
seen,
Conducted a survey.
so far we have seen that
Yes.
it has been done,
Yes, ma'am.
but he is not still satisfied. So let the boundary mark properly demarcated on the ground. So that demarcation is to be finalized and made permanent by erection of boundary marks, boundary pillars.
Yes, sir.
And there, but however, there shall not be any further action as regards possession. Parties will maintain their possession.
Yes, sir.
As per my instruction, there is no disturbance, my lord.
I have also found Mr. Loskar has complicated the matter
Yes.
because there are elders who have settled the matter, but still Mr. Loskar is disputing. Now possession will be permanently yours. Now he is complicating the matter. I have found that his submission is not in tune with the stand of the petitioner before the village elders and all the authorities. So it is up to you. You will suffer. Heard Mr. H.A. Loskar, learned counsel for the petitioner. Mr. Ms. N. Borule, and standing counsel, Revenue Department for the respondent number 1. Mr. J. Henry Glenn, engineer, government advocate for the respondent number 2 and 3. And Mr. M. H. Rajbor Pia, learned counsel for the respondent number 4. Post of para. In this petition, the petitioner has stated that as per the title deeds, the petitioners, the family of the petitioner is the owner of the following schedule of land. Paragraph 4 does. Dag number so and so, patta number so and so, measuring so and so likhibo. Who is the respondent of 4? I rule. Would the boundary likhbo nalage. Dag number 205, 206, sorry, family officer are owners of a parcel of land measuring 2 bighas, 14 kathas, 10 gandas, covered by dag number 205, 206, 207, 208, 209, 210, 211, 212, then 212/1080 and 206/872 under patta number 62 at village Bornopur, at Porgona Bornopur, Mouja, Mohammadpur, Part 1, Lala Revenue Circle, District Hailakandi. Post. It is further stated that the respondent number 4, whose plot of land is in the western side of the petitioner's plot of land, made an attempt for encroachment and raised a permanent and for raising a permanent structure thereon. Full stop. Para stating that the petitioner's representation for demarcation of his plot of land was not taken into consideration. The petitioner has approached the court seeking inter alia direction to the respondent authorities, more particularly the respondent number 3, to cause to initiate a demarcation process in the western side boundary of the petitioner's plot of land pertaining to DAG number 205 to 212 under Patta number 212, 212/1080 and 206/872 under Patta number 62. Full stop. Para. Mr. Hendik, Junior Government Advocate appearing for the S1 number 2 and 3 has placed a report of the respondent number 4, report dated 20/01/2026. Submitted by the respondent number 3 to the respondent number 4 via an office letter number so and so, dated 20/01/2026, a copy of which was also endorsed to the Junior Government Advocate Assam in connection with the present writ petition. Also, in the report, the respondent number 3, said report dated 20/01/2026, the respondent number 3 has also enclosed the paragraphs comments pertaining to the subject matter in the present writ petition. Full stop. From the paragraphs comments, it is noticed that after receipt of notice in the present writ petition, the respondent number 3 deputed 3 land revenue staff rail revenue staff for by an order dated 5/1/2026 for demarcation of boundary of the parcel of land covered by DAG number 201, 211, 202, 872, and 210. Under second RS Patta number 62. On 8/1/2026. And to report compliance. Full stop. For carrying out the demarcation process, notices were issued to Khairul Islam Sheikh, Abdul Jabbar Sheikh, and Riazuddin Sheikh. Whose some notices were also issued to the respondent number 4, Khairul Islam, Saharul Islam. Khairul Islam within bracket respondent number 4. Saharul Islam, Kamrul Islam, Hussein Ahmed Sheikh, Moina Mia Sheikh, Anamuddin Sheikh, and they submitted a number of documents, including a title deed number 4651 dated 15/5/1967 in the name of Ramuj Ali, who was the predecessor of Khairul Islam Sheikh and others, on 6/1/2026, before the respondent number 3. First of the respondent number 3 filed a petition dated 6/1/2026. So someone received the petition dated 6/1/2006 and the enclosed document from the respondent number 4 and others. It was found that demarcation of the boundary of the petitioner's land had already been settled with the intervention of the local elders. With by execution of a memorandum of understanding dated 3/11/2024. Wherein the petitioner and his brother Alauddin Loskar on one hand, and the respondent number 4 and others on the other hand, had subscribed their signatures in presence of 6 number of local elders, and both the parties authorized the local elders to settle the boundary dispute between them. Full stop. On the basis of the conditions of the MOU dated 3/11/2024, the local elders demarcated the boundary and posted pillars on 10/11/2024 in presence of both the parties, including the petitioner, and a compromise petition was signed by both the parties, including the petitioner, on 10/11/2024 in presence of witnesses. Full stop. A copy of the said MOU. A photocopy of the said MOU bearing the signatures of the petitioner and the respondent number 4 along with others has been enclosed with the report of the respondent number 4. Full stop. Further, it is further seen that the MOU the memorandum of agreement, MOU no, memorandum of agreement, had also been registered on 10/11/2024, wherein the signatures of the petitioner and the respondent number 4 along with others were present. Poster. Para, be that as it may. In the report submitted by the land revenue staff, deputed for carrying out the demarcation proceeding by order dated 5/1/2026, the land revenue staff in the report dated 8/1/2000. It is mentioned that at 11 a.m. on 8/1/2026, demarcation work was conducted in presence of the concerned parties. Full stop. As informed by the petitioner, the report further stated that as informed by the petitioner and as per records, the land falls under DAG number 211 and DAG number 212, and the boundary dispute relates to DAG number 212 only. Post of the report further mentions that in presence of both the first party and the second party, boundaries of land under DAG number 212 have been properly demarcated on the ground. Post of. Para Mr. Law Scholar and the counsel appearing for the petitioner has submitted that though the boundary have been demarcated on the ground, boundary pillars on the demarcated as per demarcation have not been installed on the ground. Post of. If the taking into consideration the submission of the learned counsel for the parties, taking into consideration the report dated 8/1/2026 and the comments of the respondent number 3 and the submission of Mr. Law Scholar and counsel for the petitioner, if after demarcation of the boundaries of the petition and respondent number 4 on the ground, no boundary pillars are installed, then the respondent number 3 shall finalize the demarcation of the boundaries, as demarcated on boundaries of the plots of land, as demarcated in on 8/1/2026 shall be installed with boundary pillars at the cost of the petition. Full stop. The boundary pillars are to be provided by the petitioner to the land revenue staff along with and the boundaries pillars and the labor, necessary labor are to be provided by the petitioner as per the direction of the response number 3. And after the same are provided, the land revenue staff
Lordship,
will install the boundary pillars on the ground.
kindly put the dag number that, my lord.
Huh?
That
2 and 2 I have said already. Full stop. It is clarified that the status quo as regards possession of the respective plots of land are to be maintained by the petition and the response number 4, and the response number 3 shall ensure the same. Full stop. If in the process of demarcation it is found that any part of the land of either the response number 1 of petitioner or the response number 4 is in encroachment of the other, the same is not to be decided in a demarcation proceeding. This order disposes of the writ.
Most alike.
22.
May please your lordship.
Yes.
May please your lordship. My lord, I am for respondent number 3 and 4, your lordship. For
3.
3, I have already filed the affidavit.
Okay.
Only and I request some more time for filing for respondent number 4, your lordship.
Response number 3.
Respondent number 3, I have already filed the affidavit of opposition in last occasion. And I request some more time for filing for respondent number 4, your lordship. Respondent number 3 is the state of Manipur, and the respondent number 4 is the officer in charge of police station, your lordship.
Okay. What more information response number 4 will bring in on record? If the state of Manipur has filed the affidavit, what the officer in
yes.
charge can bring in more?
No, that in that case, your lordship, whatever the stand taken by the respondent number 3, that respondent number will take the same stand.
Okay.
I am also appearing for respondent number 3 and 4. Then the pleading from my side may be completed.
Because if the state of Manipur has filed an
Yes,
affidavit,
yes, and the authority
if
is not
the officer in charge
yes,
can
your lordship.
bring some more information on record, it is okay. But if
No,
if he reiterates the stand of state of Manipur, then further
Yes.
affidavit from response number 4 is
Yes,
not
yes,
necessary.
not required, as your lordship, please. And the authority here goes to the respondent number 2, your lordship, 1 and 2, the passport office.
Okay, we'll
They are
ask
supposed to-
response number 4,
Yes.
2, 1 and 2. Yes, madam. You are appearing for whom?
For Union CGC.
CGC.
Respondent 1.
1 and 2?
Yes, yeah.
2.
Yes.
So he has filed an affidavit.
Yes.
Okay. Yes. What do you want?
Your lordship, basically the arguing council is from Manipur. Some
Huh.
issues happened recently, so today he could not come. I'm praying for a date after vacation, your lordship.
Okay. Miss
A. Jane on behalf of B. Deka.
A. Jain, Learned Counsel on behalf of B. Deka, Learned Central Government Council for the response number 1 and 2, and Mr. N. Anik Singh, Learned Counsel for the respondent number 3 and 4 are present. Mr.
C. Gogoi.
C. Gogoi, Learned Counsel. Who is your arguing counsel?
Your lordship, A. Sahu.
Has sought an adjournment on the ground that Mr. A. Sahul, Learned Counsel, who is leading him in this case, is unavailable today due to personal difficulty. He has thus sought for listing of the case after the ensuing long vacation in July. Post up. It is found that the respondent number 1 and 2 has and the respondent number 3 have filed their counter affidavits. First up, lays the case as sought for by Mr. Google, is the case on so and so.
Your Lordship, Your Lordship, may I bill for a fixed, yeah, much of.
2907,
Much of-
29 July.
Obliged, Your Lordship.
Item 23.
Yes, affidavits.
Petitioner was directed to furnish an extra copy, Lordship.
Already, sir.
As per record, no, Lordship.
Extra copy is already directed.
Directed, last order, Lordship.
Lordship, I have,
Previous order.
yes, I have already.
We are
submitted.
newly appeared.
No, that you submitted already on the previous date. Is it not?
Yes, Lordship.
Extra copy not furnished.
You are BC Musahari.
Yes, Lordship.
You appeared on the previous
Yes,
date.
yes, Lordship.
And
But
extra
at the
copies
time,
were directed.
Directed, Lordship, but not served.
Served.
Stamp-
How can I, shall I appoint a private
On
investigator?
record, not available.
You resolve this issue, however. We'll go on investigating whether you have served or not. You can decide it amicably. Yes, how much copies you want now?
One copy, Lordship.
One copy will do.
One copy.
Madam, 38 pages.
One scan copy. And
Give a copy. Okay, Miss,
Sina Khat.
for the petition.
Yes. Among circle. Yes, sir, maybe.
Petitioners.
Maybe.
Aforesaid, Revenue, 1. N. Goswami,
I'm for
Junior Government Advocate, Assam, 2. Mr. B.C. Musahari,
respondent number 3, my lord.
Learned Counsel, Standing
3
Counsel,
and 4.
BTC for the respondent number 3 and 4. Mr. Goswami, 2 and 5.
6.
6 also.
Yes, yes.
Who is this, all this? Learned Counsel for the respondent number 7 to 12 is found absent today on call. Mr. Musahari has submitted that he has not been provided, he has not been furnished with the copies of the writ petition, as directed, as observed by the previous order dated 13/5/2026. However, the said submission is objected to by the learned counsel for the petition. Was to be that as it may, Ms. So learned counsel for the petitioner shall furnish an extra copy of the writ petition. A copy of the writ petition will be annexed to Mr. Musahari by tomorrow. Post up. After receipt of the copy of the writ petition, the learned standing counsel PTC shall make endeavor to file its counter affidavit within 3 weeks' time. Place the case on.
2407. Item 25.
My please, Your Lordship. Lordship, I beg for some time, Your Lordship, to file an additional affidavit. Your Lordship.
Eviction law, we have filed our affidavit law.
Documents, this one, river erosion. Lordship, some river erosion documents, certificates are there, so we have to file the additional affidavit. Lordship.
Page 62 is the
Just a minute. No, notices were issued to you.
Yes.
Yes, Your Lordship.
and you reply to those notices,
Yes,
Yes, your lordship.
right?
yes,
And with an apprehension you have come.
yes,
Court has observed Salakoti is to be observed.
yes.
Now, if you want to file any additional documents, you
Before-
file it before the
before
authority,
authority,
not
yes, yes.
before us.
Yes,
Lordship, earlier this honorable court has asked for the river, if the petitioners are really
No,
river
no.
eroded.
We are not going to examine your river erosion. It is the authority
Yes.
who has issued the notice, he will examine. Right? Court has said to proceed with a hearing, however, no final order has been passed without leave of the court. This is the order you have got from the court, meaning thereby they are restrained from passing the final order.
yes.
Now, if you have any document to submit, I can grant you liberty to file it before the
Yes,
authority,
yes,
not here.
yes, yes.
By way of additional affidavit in reply. No, that is not the issue. Is it not?
The petitioner.
Parallel proceedings are to be prohibited. Proceeding is going on. Final orders are to be passed. But if you require some time, that is another matter for filing it before
Authority.
the authority, not here. We are not going to examine that.
Lordship, the petitioners are landless.
That
landless
is you.
Because.
You plead it before him, not
we have
before us.
filed
That
a
is not the order. When you move the writ petition, you said no final orders have been passed. Writ petitioners apprehend that since no orders are passed, authorities may proceed to take steps to evict the petitioner from the concerned land. Then senior counsel has said that Salakuddin should be observed. So, if you don't have that document at that point of time, now for within 6 months, you must have collected all those.
Yes.
Lordship, give me some time.
Take a call. This is not this way. The two parallel proceedings that this court is directed not to take final order.
Again.
Here the proceeding is prolonged. That authority is prevented from passing the order. By that way, two parallel proceedings are going on. This is not the way. One has to be stopped, and this is to be stopped.
Lordship, might kindly.
Day after
give a date,
tomorrow.
your lordship.
If you want that I need some more time to collect your river or erosion thing, I can grant you time, 2-3 weeks, whatever you want. Till that time, that authority shall not pass the order, and I'll grant you liberty to file those documents before that authority, and that authority should consider all those documents before passing the final order. Thereafter, he'll get the final order. If it goes against you, you have the opportunity to file a writ petition. Is it not?
Yes, sir.
But you are parallelly proceeding two things.
No, your lordship,
I don't think
earlier this honorable
it
court
is-
has asked
it-
for
it
the
needs to be
river
continued.
erosion certificates, your lordship.
That you take your call. But by filing this petition, you will prolong this.
Yes.
That will also be prolonged. No, this is not the way.
Your lordship, maybe fixed after 1 week, your lordship.
Friday, on the prayer of Mr. Aforesaid,
Your lordship.
Learned Counsel for Professor, release the case on Friday. Mr. Aforesaid,
About 3 and 4.
Aru N. Goswami,
3 and 4.
1, 3, and 4 are private.
19
Interim order passed earlier. Shall
First
continue.
Saturday. Huh?
Daily list, item 26.
Mr. B. Gogo will appear in this matter, my lord. He's arguing a different matter which is fixed to a tender matter, my lord.
Okay.
After some time.
After some time.
27.
May. In this case, instruction was sought for regarding development of investigation.
Instruction.
Affidavit. No, I think should say RBI details scan to place it.
What do you mean by mule amount account? MULE. Is how MULE meaning? Which for the bank?
Man, I for the bank, Malot. Man, here, Malot, what happened, Malot? Since there is a complaint raised by him regarding the server fraud, so his bank account was freeze. And as per the RBI policy, Malot, that we are required to conduct an investigation as to how the money has been siphoned out. So there has been, as per my instruction, man, there has been some internal investigation, and it has been found that the money was transferred by his own will, Malot, by sharing the OTP and the other password messages. So during the pendency of the investigation, Malot, a temporary credit has been given to him. But that till the pendency of the internal investigation, that temporary credit has to be given to him as per the RBI guidelines. And afterward, it was found that since it was transferred through his own OTP and passwords, so again the money has been taken back. But however, there is a discretion on the bank also, that the waiver, whatever the loss the customers acquired, that can also be waived off by the bank.
So that instruction has been waiting, we've been waiting. It may be waived off, may not be, that we are waiting because the instruction comes from the Mumbai team, whether they can be waived off or not, only that part. And as far as the defreezing is concerned, we don't have any objection. If your lordship directs, we can defreeze it, his account today.
But,
And we'll file our detailed affidavit in 2 weeks.
But whereas this 7,03,738,
That
basically that is kept on hold.
No, according to my instruction, that has been taken out from his account. I don't know how it. Since there is a complaint, he has been raised. So as per the RBI, we have to give a temporary credit. If it is found that it's because due to the fault of the bank system, then the 7 lakh which was given temporarily to him, it has to be given permanently to him. But now, as per the instruction which I have received, it's again be taken back because as per the investigation, the money has been transferred at his own discretion.
Now, this is a loan account.
Yes.
Now, what difficulty you are facing now? This 7,03,000 that they have to take a permanent call, right? That the investigation is going on, internal investigation. So far as what difficulty you are facing now in operating the loan account?
My account is freeze, lordship, and lordship, whether this amount is either deposited in my account or not, I am not sure.
That is what they are saying.
That's
They
my
will,
instruction.
temporary hold was there, but the internal investigation is going on. Whether it will be that 7 lakh will be permanently transferred to your account for your utilization or not, that decision has not been taken as on date. So what other difficulty you are facing? Apart from recovery of 7 lakh?
Lordship, I took the amount.
That I have understood.
Yes.
Now, apart from this 7 lakh,
Yes.
where in respect of which a final decision is yet to be taken, right, to permit you to utilize that amount or not, or what other difficulty you are facing as on date?
Lordship, at this stage, lordship, my account may be decreased, lordship, and I can make my transaction, lordship.
Yes, that differs. Then later part we will file our detailed affidavit and will take our stand.
In your synopsis,
Yes.
I have gone by your synopsis.
Yes, lordship.
There you said the account was freezed by bank
Yes, lordship.
on 25th July,
Yes.
but your statement of accounts does not say so. It was on 25. On which date it was freezed?
It, as per my instruction, it was fixed on 25th July, lordship.
But that definite date also I have to take instruction of whether on which particular date it was placed.
Because nothing, in their instruction, nothing. You have not obtained any instruction till date.
Manan, I have given my stand, Manan. The instruction I'm waiting from the Mumbai, whether they bank, whether they are going to waive the amount or not, Manan.
Because he says as per his information.
Manan.
But bank statement, bank account statement does not indicate so that 25 July,
Yes, Lordship, immediately after the transaction, I filed complaint.
25 July, no, it is not there. It might be in October.
No, whether the freezing part, Manan, it doesn't reflect in the statement of account, Manan, the exact date.
Because it has been siphoned off on 9/10/2025.
No, Lordship, on 25/7/25, Lordship,
But bank account says no, on 25/7/2025.
25, Lordship.
It is not there. On that day, you have made some payments.
Lordship, page 18,
Okay.
Lordship. Page
Or
18 and 19, Lordship.
on that day, you have been making payments, 4 transactions to Dadra and Nagar Haveli. 4 transactions, 4, 5, 6.
These are the fraudulent transaction, Lordship. Without my consent, Lordship, this transaction.
That has to be
And the
determined.
entire amount is 7,03,738, Lordship. There are 6 transactions. Page 18 and 19, Lordship. Below question.
Please, Mr. HDFC Bank, you have to give some info.
Manan, I will give Manan. The 2 weeks time again, we'll file it before it's Manan, have all the details.
On what date those are withdrawn and what date you have given this temporary credit?
My
At
lord.
least that information should be there.
But it
You know,
will be there,
instruction.
Manan, by this week or by at the most by next week, we'll file our
We
details.
have been pursuing it since February.
My lord, I've been, because the instruction has been, no, on a last chance, my lord. By next week, my lord, by this week, we'll file an affidavit. There's a last chance, my lord.
Okay, let us see.
Yes.
Heard Mr. S. Alam, learned counsel for the petitioner. Mr. N. Goswami, learned junior government advocate for the respondent number 1, 2, and 3, and Mr. M. Smith, learned counsel for the respondent number 2. Post Mr. Goswami has placed the set of instruction received from the senior superintendent of police, Nagaland, by him from the senior superintendent of police, Nagaon, wide office letter under memo number so and so dated 15/6/2026. Post Mr. Smith has sought for a week's time to obtain instructions regarding the transactions made in the bank account of the petitioner during the relevant time, whereby an amount of rupees 7,03,738 was shown withdrawn from the bank account of the petitioner. Poster. Okay, raise the case on Monday. The instruction kept by Mr. Goswami is kept with the case record. Investigation is going on. Let us see what the bank says
Yes, Lordship.
about your recovery of 7 lakh.
22/06/22. 22nd June.
Give the details when these transactions were
My lord.
taken place and thereafter, what is the decision on your side, from your side?
My lord.
My instruction kept in record. Kept in record, we'll pass the necessary order on the next day. Because if that is mitigated, thereafter if he is not satisfied with the investigation, he can approach the jurisdictional magistrate, right? Yes. The manner in which the investigation is being carried out. But question is about recovery of the money. Yes.
28. Item number 28.
Yes.
Please, Your Lordship.
Here it is available, right?
Lordship.
The other one, in the previous.
Lordship, that was not there.
Now, who is the authority?
Lordship, in the amended cost title, nodal officers, cyber cell officers.
DGP.
Respondent number 5.
Give this
Lordship,
details of this party
yes,
with you,
Lordship,
so that,
Lordship.
yes.
Now,
Here, my lord,
notice has to issue to Lordship, he has to serve me the copies.
who will receive notice? You?
Lordship.
That's one number 5. Yes. Bank?
Bank
Bank they have filed affidavit, my lord, on the basis of one email, my lord. Account has been freezed, the entire account has been freezed, and disputed amount is, my lord, 20,000.
20,000.
Lordship, 20,422.
Yes, Mr. You get the instruction.
And they have filed, my lord, bank has filed that they received a email from the station house officer on the basis of said email, entire account has been.
Mr. Royal get instruction on it within 1 week time. Thereafter, will allow you to operate the bank account, keeping a lien,
And as
if
per-
permissible, if permissible.
And there is no case pending against.
That I don't. That cyber complaint, we don't know. Let him get the instruction.
Bank filed affidavit. According to them also.
Bank, no, it is the cyber authority who can ascertain that no case is pending against you, not the bank. Heard Mr. R. Ali, learned counsel for the petitioner. Mr. U. Shoikia.
Yes.
Learned counsel for the respondent number 1, 2, and 3.
Amended cost title.
Union of India.
B, last date, B Chakraborty appears.
Okay. And Mr. S.S. Roy, learned junior government advocate for the respondent number, for the newly implemented respondent number 5, full stop. As let notice be issued, as the respondent number 5 is a newly implemented respondent party in the present proceeding, let notice be issued as Mr. Roy has already appeared and accepting notice on behalf of the respondent of 5. The notice be returnable on next Monday.
22nd, 22nd June.
The Mr. Roy shall obtain instruction as regards the cyber complaint received in connection with the transaction made in bank account number 640-401 792 maintained by the petitioner at Dhubri branch of the Bank of Baroda. Full stop. It is a case of the petitioner that the suspected transaction is only in relation to a sum of rupees 20,000.
20,422.
422. Full stop. Mr. Roy shall also obtain instruction whether the cyber complaint is in respect of the sum of rupees 20,000 so and so, or for any other amount, and to place the instruction before this court on the next day of listing, list the case on Monday.
May it please your lordship. Lordship, as per the last order, we have submitted the documents, required documents. In terms of respondent number, petitioner 2 and 3, your lordship.
Your application has also been forwarded, my lord.
Forwarded.
Lordship.
Where is the CGC? Yes.
Lordship, I have to take instruction on 26. I think that 26 they have forwarded.
Okay. heard Mr. S.K. Sakma, learned counsel for the petition. S.S. Roy, learned central government counsel for the respondent number 1. Miss M. Borman, learned junior government advocate Assam for the respondent number 2 and 6. And Miss S. Sharma, learned standing counsel Health and Family Welfare Department for the respondent number 3 and 4. Post of para. Mr. Chakma has submitted that after 18/5/2026, the respondent number, the petition number 2 and the petition number 3 have submitted the relevant documents along with photographs at the office of the respondent number 6 or 2. 6 on
26.
26/5/2026. Full stop. On submission, on receipt of the Miss Borman, Miss Borman, appearing for learned government advocate, appearing for the respondent number 6 has submitted that on receipt of the documents, the office of the respondent number 6 has already forwarded the said documents to the Ministry of Home Affairs, Government of India, at New Delhi on 26/5/2026 for, along with a report, for grant of additional compensation of rupees 1 lakh each to the petitioners who are acid victims, acid attack victims.
Yes, sir.
Post of. Mr. Roy, done as CGC, has submitted that he will need how much? 2 weeks' time to obtain necessary instruction as regards the processing of the applications of the petitioners for grant of additional compensation of rupees 1 lakh each. The submission made by Mr. Roy is accepted, lays the case on so.
2007, 28 July.
Get concrete information.
33.
May please, the Lordship.
Yes.
Lordship. Okay, we have received the instruction, Lordship. A petitioner could not file a relevant document. That is why the NOC was not issued, my lord. Para 3 and 4. 2 also important. Lordship.
Who is the applicant?
Lordship, here in I am intending procedure upload of land, Lordship. Whatever required documents, Lordship, I have uploaded. And Lordship, in rejection order, Lordship, page 47, it's reflected, Lordship, that sufficient documents has not been submitted. But what type of documents required, that part has not been indicated. Accordingly, Lordship, my petition has been rejected. I have made an appeal before the district commissioner's Lordship, that is page 49. On being received this appeal, my application has been restored, Lordship. In so modo, it's restored. And in restored, Lordship, and a query has been made, Lordship. But on that day, Lordship, on 8/2/2026, I have replied that query, Lordship. So, Lordship, now, Lordship, whatever instructions, Lordship, by way of instructions, they cannot improve their stand, Lordship. In their rejections, Lordship, they did not mention what type of documents is required. And Lordship, I have also annexed the Lordship, that is page 35. What type of documents is required? That is page 35, Lordship. It is a lordship is very much your lordship. It is an online portal, and portal is everything is their lordship. Lordship, here lordship, whatever documents is required, it mentions, and all the documents I have uploaded, lordship.
Now they are saying, with regard to page 35,
Lordship.
supporting document,
Lordship.
serial number 2.
Yeah.
Now they are saying
Lordship.
that voter list of
66,
71, and 51 for verification purpose.
Lordship, here 2 is not. Lordship, 2 is, lordship, I have uploaded my voter identity card as well as the
Voter identity card is not citizenship.
lordship. So what
That is settled. Voter identity card is not citizenship.
lordship?
They want your perhaps linkage document or whatever because you are petitioning in person.
Yes, lordship.
So 51, 66, 71.
Lordship, that's why I am saying, lordship, in my appeal, I have stated what type of documents required. You will just tell me.
Right. No, it's now rejection of a application or pendency. They have said now that these are the documents.
Lordship.
Now, if the appeal is pending, I can allow the appeal
Lordship, no, I am not.
to be disposed of.
Lordship, I am not.
Or otherwise, you have an option in view of the instruction placed. You can furnish the documents to the authority, these documents which now they have said. Then get the application
Lordship,
processed.
Lordship, that's why in my appeal I have stated they have to return back, revert back my applications in online portal. That's why then I can upload my application.
No, you want the application to be processed or you want the dispute to be adjudicated?
No, lordship, I am not.
No, which one you would prefer?
No, lordship, lordship, my submission is very limited, lordship. Now, lordship, kindly see their rejection or I am just indicating their intentions, lordship.
Okay, overlooking everything, you want your application to be processed.
Lordship.
Is it not? Ultimately, you want your application to be processed.
Lordship.
Or not?
Lordship, I have.
Or your appeal to be decided, again rejected, then you go to the some commission is there now, second appeal,
Lordship.
then repetition. Which one you would prefer?
Lordship.
If they want these 3 documents, whatever of your parents or your grandfather,
Yes, lordship.
give it to them.
Obviously, lordship, I have nothing to say, lordship, but
so better, or you want the legal issues to be decided.
Lordship.
Which one? Tell me.
Lordship.
Don't flip-flop.
No, lordship, my first submission is that, lordship, in the rejection order. Now, today I have.
Then you let them file affidavit.
Lordship, today my lordship.
Let them file affidavit. I have given you, I am trying to make you understand that they are saying that these are the documents they want. If you want to provide this document, I can ask them that petitioner will furnish these documents within a period of 15 days. Then after received, you process the application afresh along with the documents already submitted. That is one. And second is, we'll ask them to file affidavit. Then thereafter you file reply. We'll decide.
Lordship, my submission, lordship, lordship, whatever court is saying, lordship, absolutely, I have also agree. Lordship, let the whatever documents required,
because APIC is not a document regarding citizenship. Our division bench says, hell.
Lordship, yes, but voter list also.
Because they have not decided, have not disclosed what kind of documents are found deficient.
Yes.
Now they are coming up with a plea that 66, 71, and 51.
Lordship.
Give them.
Lordship.
That's all. Instead of filing an affidavit, thereafter you will file a reply, then appeal is pending. I'll ask the appellate authority to dispose of the appeal. Again, rejection order, second appeal.
Lordship.
Madam, I will dispose all of it.
Give 15 days.
Lordship, if today the application rewarded back my now instead I can provide it, lordship. Instead.
You get this, I am permitting you not to all these formalities. Which office?
It's Lordship Dhubri district Lordship.
Which office? Circle officer?
Agomoni.
Circle officer
Yes, Lordship.
or district commissioner?
No, circle officer, Lordship.
Okay, you will file this document before the respondent number 4 within a period of 15 days. On receipt of this document, the respondent number 4 will process the application and pass a revision order within a next period of next 15 days.
Lordship.
That's all.
Yes, Lordship, then my one more submission, Lordship, my petition may not be disposed, Lordship, till next 15 days. Otherwise, there will another round of litigation.
No, I cannot pass the order
Lordship.
for him. I cannot assume his authority.
Lordship.
He has been given statutorily the authority.
Lordship.
I can only supply the loopholes. After he passes on order, we can examine his order is right or wrong.
Lordship.
But we cannot pass the order on his behalf.
Lordship.
He wants the repetition to be.
No, I have to issue a mandamus directing the sale permission,
Lordship,
which is not permissible in rural jurisdiction. Neither by way of mandamus nor by way of certiorari. Heard Mr. I. Hawk, the petition in person. Petition number 1 in person.
Lordship.
Mr. H.K. Hazarika, learned junior government advocate for the respondent number 1, 3, 4 and 5. And Mr. A. Aforesaid, learned standing counsel revenue department for the respondent number 2, postal. It is the case of the petitioners that the petitioner number 1 as the proposed purchaser and the petition number 2 as the proposed seller had entered into an agreement for sale of land. Agreement for sale of a plot of land. Measuring 2 kathas, 10 lessas, covered by dark number 886 and KP Patta number 118, situated at village Bidar Dabri, paragraph 3, part 3, Agomoni Revenue Circle, District Dhubri, Assam. In order to obtain the notified public service, namely composite land sale transfer, the petitioners submitted an application along with the relevant documents before the respondent number.
Lordship, it is online portal, Lordship. I am not
in the online portal,
Lordship.
On 13, sorry,
on 24/7.
Where is that?
Lordship, it is page 36, Lordship. On 24/7/2025. And in acknowledgement, the application was received. Void acknowledgement number, page 36, NOC/02/53618/2025, dated 24/7/2025. On the premise that if the application was to be accepted, then the service should be provided within a period of 45 days
Full stop. When it was rejected,
Lordship, that is page 47, Lordship. It is rejected on 1747, Lordship.
however, on
1710, 2000.
2025, the application submitted by the petitioner was rejected by the respondent number 4 on the ground that the patadar, the ground of insufficient documents. As remarks, it was mentioned that the patadar failed to submit documents. Full stop. Agreed by the order of rejection, the petitioner preferred a first appeal before the first appellate authority under the provisions of Right to Public Services Act 2012 as amended on
Lordship 2212.
22/12/2025. Full stop. As the appeal was, what happened to the appeal?
Lordship, on being received this appeal, my application has been restored. That is page 50, Lordship.
Page 50.
Lordship, it is application tracking status, Lordship, and started 51 page number, next page.
Page 51.
51, Lordship. It is status showing, Lordship, next page, Lordship, 51. It's a right side, Lordship. It is a current status, query made, Lordship.
When the petitioners inquired about the status of appeal, in a designated portal, the status of the appeal was shown as quote unquote query made. On which date?
Lordship, it's Lordship, it is not mentions the date, Lordship.
Okay.
Then next
up?
page, Lordship, kindly. Next page is mentions 8/2/2026. The citizen has replied to the query. I have replied on that day, Lord.
As the fate of the appeal was not known to the petitioners, the petitioners have preferred the instant writ petition under Article 226 of the Constitution. Full stop. Para. One of the grounds urged on behalf of the petitioner is that though the application was rejected on the ground of rejected on 17/10/2025 on the premise that the documents submitted by the petitioners were inefficient, but the rejection order did not disclose the nature of deficiencies found in the application of the petitioner for the notified public service composite land sale transfer with regard to the documents. Full stop. Notice was issued to the respondents on 13/3/2026. Post of para Mr. Hazarika, junior government advocate appearing for the respondent number 3 and 4 has submitted on receipt of instruction from the respondent number 4, in the form of an office letter number so and so dated 8/5/2026 addressed to him, that the permission, sorry, the notified public service composite land sale transfer was not extended to the petitioner in view of deficiency of a number of documents, that is, voter list of 1951, 1966, and 1971. It has been mentioned by the respondent of 4 that the same are required for the verification purpose, since as Dhubri district is being adjacent to the international border, the same documents are particularly essential in matters relating to land transactions. Para. Having regard to the present status of the application, Mr. Hazarika has submitted that if the petitioners submit the deficient the documents which were not submitted earlier within a reasonable period of time, the application submitted by the petitioner on which date? What is the date?
24/7/2020.
27.
24/7.
24/7/2025 can be processed further for extending the notified public service. In view of the above submission made by Mr. In response to Mr. Hawk, the petition number 1 in person has submitted that the requisite documents can be submitted within a period of 15 days from today. In view of the above submission made by the learned counsel for the parties, this and notwithstanding the fact that the appeal of the petitioner is presently pending before the appellate authority, this petition can be disposed of with a direction to the this petition can be disposed. This court is of the considered view that if the petitioners submit the deficient documents, mentioned here in above, within a reasonable period, the writ petition can be disposed of with a direction to the respondent of 3 and 4 to process the application of the petitioner dated 24/7/2025 submitted by the petitioner to further process. Mr. Hazarika has submitted that if the petitioner submit the applications or documents within a period of 2 weeks from today, the application can be processed further and a final decision can be taken within the next 2 weeks from the date of submission of such documents. In the efforts taking into consideration the submission of the learned counsel for the parties, it is directed that the petitioner, it is observed that the petitioner shall submit the voter list of 1951, 1966, and 1971 within a period of 2 weeks before the respondent number 4, along with a copy of this order. It is directed that the respondent number 4 is directed that on receipt of such documents from the petitioners, the application reference number so and so shall be further processed and a final decision shall be taken in terms of which notification? Composite cell transfer.
That is page 31.
31. In terms of the notification for composite land cell transfer dated 11/11/2022 of the Revenue and Disaster Management Department within a period of next 2 weeks from today, and the order passed thereon shall be communicated to the petitioners immediately forthwith thereafter.
Lordship, one point I can indicate, Lordship. That Lordship, then now this process is online. Now I cannot serve these documents by hand, and as because they have to maintain in online portal
Okay, manually,
manually.
manually.
Lordship.
He can upload, circle officer.
Lordship.
Himself he will upload. If the portal is closed, he can open it and he will upload whatever, manually. In physical form. Physical form. This order disposes of very petition. Right? 15 days you submit, he will take manually in physical form all the voter list, then he will process the application further, notwithstanding the pendency of the appeal before the first appeal. Yes, anything to be said? And final decision is to be communicated or uploaded in the designated portal.
Highly appreciated.
Region decision, huh? Region decision.
34.
Right? Instead of appeal, you pursue first appeal, second appeal, it will process,
Lordship.
take long time.
Item 34.
Lordship, we have received a pair-wise comment. Lordship, I may be allowed 2 weeks time for filing affidavit.
Before that, Lordship, I am for the private respondent number 4. This is a civil nature case, Lordship. And this writ petition, it doesn't disclose the locus standi of the petitioner to file this writ petition. If your Lordship sees the cause title, this Indrajit Boro, he's filed this case in his personal capacity. Then he says, Lordship, in paragraph 2, that he is the power of attorney holder of one Najibur Rahman. And he also says that Najibur Rahman is the absolute owner of the 4 kotha 15.30 lesas of land. Now, if Lordship sees the document at page 28, they have annexed the Jamabandi of the concerned land. He's Najibur Rahman at serial number 4. His father is this Danishur Rahman and his uncle is Habibur Rahman. So he cannot give a power of attorney of the entire plot of land. And he cannot claim that he is the absolute owner of this particular land. And he doesn't, this petitioner also did not disclose who are the other legal heirs of the Danishur Rahman. And secondly, Lordship, they have disputed the boundary. It is already well demarcated, 2 separate plot of land. It is well demarcated. If Lordship sees that Annexure 3, Annexure 5, Lordship, sorry, at page 36, they have Annex 1 map. This 64 is of our my father's land, and 65 is their land, according to
Your home. Anamika Sharma.
Yes, I'm daughter of Sushil Kumar. He purchased this land, particular land.
Who purchased this land? Which one? 64 is?
They are concerned with 65. That's
Yes.
Doug number 65.
Yes.
We are concerned with Doug number 64.
Okay.
We have my father purchased this Doug number 64 in the year 2003. Took possession, demarcated, and the land that the boundary, entire boundary is demarcated, and there is a boundary wall. And it was built in 2004. Now they have what they have done. They entered into my land and they constructed a tin chali. On that point of time, they also lodged an affair. We also lodged an affair. Now that demarcated dispute, who is initiating, Lordship? Kindly see, by the police officer, not by the person concerned. At page 41, the Gorsuk police station, he wrote to the circle officer for page 41, Annex 9. A police officer is initiating a boundary dispute before the circle officer.
What is the prayer medicine?
Prayer for demarcation and all, because Lordship knows that regulation 34, regulation 23 of Assam Land Revenue Regulation, it provides how to solve boundary dispute.
whether the police officer can initiate a proceeding. Their prayer is like that, Lordship. Respondent number to district commissioner to immediately carry out a formal survey, identification, demarcation of the petitioner's land. And the basis is that police officers that annexer 9. And annexer 10 circle officer also responded to this, giving complete go by to the Assam Land Revenue Regulation. And if you see, Lordship sees the between the lines that police officer that annexer 9, they have stated before the
What
police.
instruction you have received? Yes, have this.
Regarding the co-partner of the district land. We are not co-partner, we are separate partners. We have different partner, they have different partner. Whether the boundary wall thing is reflected in their reply.
Where is the field inquiry report? It is not there.
I have handed over some photographs, Lordship.
No, some mention about half boundary wall is there.
The entire thing. I have given the photographs, Lordship. That is the frontage. That test house. He constructed, we filed the FIR. After FIR, police come to the spot and that was dismantled. It is a vacant land, Lordship. Our land is well demarcated. This age of the boundary wall itself says 2004 we have constructed, and Lordship annexer 9 in that report they have said that already constructed a boundary wall over the said land. But by way of clever drafting in the body of the writ petition, they have not mentioned that there is already a boundary wall.
Both of you file information before the officer.
Yes.
And on the basis that he said he arrives at a view that it is a civil dispute. Is it not?
Yes, yes.
And he wrote that without his interference, he had written to the circle officer.
Yes.
Is it not? He has received some complaints from both of you.
Yes, our complaint was to remove that test house from our land. That is our only complaint, not regarding any demarcation identification.
Right, but he has made it.
He has
made.
And
that is also not within his jurisdiction to remove the test house without.
because I don't know, Lord, he might have satisfied by, we have shown our document along with our FIR.
No,
We have
I am saying about the officer in charge,
Yes.
without interfering the matter,
Yes,
forwarded the matter to the circle officer.
yes.
I think that is his view. Let us see. I have not read the content.
Now,
Read the contents of this letter you have taken me.
No, my respectful submission is that he could have been said that since it is a civil nature case, he already held, the parties concerned should approach the proper revenue authority for resolve these particular issues. So far, if they have any grievances, only revenue authority can resolve it. Because apparently he didn't say any law and order situation
Let me
regarding
read
this.
it. Let me read it. Yes.
And one,
If you want demarcation of your land, file a demarcation application.
that is there. Regulation 23 is there.
File a demarcation application. It is a notified public service.
My lord, but
Don't go through the route of police.
we are in the position.
That is, we are not into the possession. Possession is different thing from demarcation. Right? Possession will not interfere. Possession, both are, it is a plot of land, both are adjacent landowners of adjacent plot of land, 64, Dag number, and 65. Right? If somebody has encroached into the other's land, both of you have alleged before the OC that he has encroached my land. He has also said that you have encroached the land. We are not into that. That is a completely civil dispute. If somebody, private person, has encroached into a private person's land, there is no role of any circle officer, officer in charge, district commissioner. Right. So far as demarcation is concerned, yes, circle officer can say and demarcate the plot of land without disturbing the possession. If thereafter, if you find that, yes, something is encroached by the other party, you go to the civil court. Is it not? There is a proper procedure?
Yes, Lordship.
And for that, you have to file a proper demarcation application.
Yes.
But don't try to use the route of officer in charge, thereafter read jurisdiction, that too by a power of attorney. And who is not the absolute owner of 4 kathas and so land. And you do not have the power of attorney from all the landowners. And some wall is also existing, half boundary wall, I don't know, something is broken also, I don't know.
That is
We are
the-
not into it.
Yes, that is.
We are not into it. But where is the demarcation application?
But the petitioner has not applied demarcation
Then
for demarcation.
demarcation
But-
application, you apply for demarcation application.
He has the 3 shall be.
Oh, don't influence the officer in charge to send a letter to the circle officer
That is
for
a
deputation of land record stuff.
wrong precedent will set, Lordship, if it's.
It seems that the petitioner, this attorney holder, perhaps is a land broker.
And Lordship, regulation.
Picture emerges from the situation. It appears to be a land broker,
And Lordship,
if I am not wrong.
if Lordship sees the para 11, this petition is also not properly shown. Page, page 11, paragraph 4, Lordship, kindly see. Page 11.
Yes. Take a call, otherwise it will be dismissed. No demarcation application. And how can you seek prayer number 2? Prayer number 2, page 9. How can you seek? In a public law remedy? It is a matter of civil court. Now directing the so and so to immediately carry out formal survey, that is by the OC, without any demarcation application. They can derive jurisdiction on the basis of a demarcation application. If deputy commissioner follows the direction of the officer in charge, then re-jurisdiction is the last resort. He is the revenue head of the district. If he follows the order of the officer in charge of some police station,
My lord, in the meantime,
no, what do you want? 2 options. One is dismissal.
my lord, kindly allow 2 days time. I will
That I
consult
can
on-
give you. That I can give you. Right, but take a call. If he insists, then it will might entail cost also. And position of the petitioner is very doubtful. His affidavit is also doubtful. And prayer number 2, not permissible. And prayer number 1, they direct the deputy commissioner to act as per the direction of the officer in charge. This court is not going to give. Then it will be deputy commissioner will be under an officer in charge. Okay, P.A. Ahmed, petitioner. Who is there? A. Bhorasaiji. And N. Boduloy. Revenue 1. H.K. Hajorika, 2 and 3. Mr. J. Dakal and counsel for the respondent 4 are present. Full stop. As sought for by Mr. Ahmed, leaves the case on. Okay, video Thursday. For this photograph, you take, otherwise it will be misplaced. Mr. Hajorika, you place this parawise comment on the next date. Or somebody else will be available, he'll say that I don't have the instruction. Then you place a copy of the instruction with the court master. Give a photocopy of it.
Item 35.
Your Lordship, in this case, we have filed our affidavit in opposition.
Okay, there is no representation on behalf of the petitioner today on call. Mr.
N. Goswami on behalf of M. Sharma.
And Goswami, learned counsel on behalf of Mr. M. Sharma, learned standing counsel IOC for all the respondents is present and has submitted that the affidavit in opposition has already been filed on behalf of the respondent number 1 to 5. As there is no representation on behalf of the petitioner today on call, let the case be listed. After 3 weeks, if the petitioner wants to file any reply affidavit to the affidavit in opposition filed by the IOC authorities, respondent IOC authorities, the same can be filed. Same is to be filed within the next 3 weeks time.
36.
My lord, may I please?
Yes, counters.
No instruction is received from the deputy commissioner also.
Okay, let them
My lord,
have some more time. R. Deuri,
my lord.
petitioner, S.K. Hajorika, 1, 3, 4, and 5. Social justice, you are social. Miss P. Chakraborty, learned standing counsel. Social Justice and Empowerment Department, Government of Assam, for the respondent number 2. So both of you file. Both Mr. Hajorika and Mr. Huh? You are 2. He is 1, 3, 4, and 5.
1, 3, 4, and 5.
Both Mr. Hajorika and Ms. Chakraborty are granted further 3 weeks time to obtain the necessary instruction and to file the counter their respective counter affidavit. Release the case on Friday. Further 3 weeks time.
Highly obliged.
Oh, yes.
Second round of litigation, my lord. Lordship will fix your 19th, my lord. I'll get the instruction, my lord.
Okay. Heard Mr. B.P. Boral and counsel for the petitioner on the request of Mr. S. Boral and standing counsel GMPA. Release the case on Friday, 19. Problems. You need a copy?
No, I have it. I'll give it.
Give a copy.
Item 26.
Mr. Gogoi. Okay, we'll call at the last.
Daily list for orders. Item 37.
Yes, some prayer was made in the morning. What prayer?
Lordship, I am appearing on behalf of NH Majavia, the counsel for the petitioners.
Why it has come?
Lordship, may I kindly see the Lojima report, Lordship. This is order dated 11/2025. Service upon number, respondent number 6.
Yes.
Lordship, kindly allow us 1 week time so that we can take fresh steps.
So you are not very much interested to appear before the Lojima court.
No, Lordship.
That
because
is,
of
it
some
appears so.
Inadvertentness, we. didn't
And
come
you
to
don't
notice.
follow the orders passed by the Lojima court.
Even then, Lordship, 2022, my lord, it was dismissed for default. After that, my lord, that so
We
many
are
times
still-
they are not appeared.
Huh.
That they have the interest on these matters, or I do not know, Lordship.
Are you flogging a dead horse or what?
Lordship.
Take your stage within 7 days, otherwise the case will be dismissed without further reference to the court.
Lordship.
Heard, Mr.
And Hazarika on behalf of NH Majavia.
Mr. J. Hendik.
For
Learned Government Advocate.
1 to 5, Lord.
Junior Government Advocate for respond number 1 to 5. Post up. Peruse the order. Orders. Comma dated 10/9/2025. Sorry. 29/1/2025. Comma dated 10/9/2025. And dated 1/11/2025 order Lojima Court. Also perused the office notes dated 9/4/2025 and dated 24/9/2025. Para. Since 29/1/2025, comma, the petitioner is found is found to have not taken any steps for service of notice upon the respond number 6 for a period of more than 1.5 years. So Mr. Hazarika has sought a last opportunity. Has sought for 7 days time, 1 week's time, as a last opportunity to take steps for service of notice upon the respondent number 6 in terms of the order dated 29/1/2025. The request is accepted as a last opportunity with the further observation that if no steps upon the respondent number 6 is taken within 1 week's time in terms of the order dated 29/1/2025, comma, the repetition shall stand dismissed without any further reference to the court. Release the case on after 4 weeks for further orders.
So in this case, I need some time. I could not locate my client actually. He was
What
very
is
late.
the subject matter?
The tender period is already over.
In that period, actually, the matter may be infructuous.
Infructuous.
It looks like infructuous. That is why your brief is not alive
Yes.
in your chamber. You have already done the file.
Actually, my junior has also gone. He has also left.
That along with his this brief, because it is for what period? 3 years.
3 years, my lord. 1 4.
You instituted this petition in 2022.
22. That is, I don't have the brief. Actually, he had. actually.
Yes, contract over.
Yes, ma'am.
Period is over.
Period over, ma'am.
Yes, Lordship, then it's okay. Okay, Lordship, I don't have brief, then also.
And you lost at the first round. And secondly, second round, no interim order also.
Yes, I remember.
We observed this tender was invited for a period of 3 years so that you are protected.
I am protected.
Heard Mr. P. Sharma, Learned Counsel for the PT. Both are same?
Same.
Both are same?
Yes, ma'am. Same.
Okay, come on order. And Mr. A. Jahid,
Yes.
Learned Counsel for the respondent.
2 and 3.
Okay. To IOC Limited for the respondent number 2 and 3. And Mr. S.S. Roy, Learned Central Government Council for the respondent number 1. First stop. Para. The petitioners in these two petitions have had preferred, sorry, the petitioners in these two petitions had assailed selection of the respondent number 4 as the beneficiary of a contract for road transportation of bulk petroleum products. Full stop. Para. By a notice inviting tender, comma, the respondent Indian Oil Corporation, by notice inviting tender, bearing e-tender number, page 16, comma, the respondent Indian Oil Corporation Limited invited e-tenders under 2-bid system from tank truck owners for award of contracts for road transportation of bulk petroleum products with effect from 1/4/2022 or at a date to be decided at the discretion of the respondent IOCL for a period of 3 years with option for extension up to further 2 years at the sole discretion of the respondent IOCL. Who is the beneficial listing? The two petitioners participated
Yes, I do not remember.
in the tender process
Yes, but
pursuant to the NIT dated. Yes, NIT dated.
NIT dated, my lord. Yes.
e-tender number is there.
It is not there. Pursuant to the NIT and a bidding and a tender process initiated on the said basis, comma, letter of acceptance was issued. No, in response to the NIT, the petitioners participated in a tender process by submitting their respective bid. Full stop. After in the competitive bidding process, the respondent IOCL Limited selected the respondent 4. Same or different name?
Different
Name defined, my lord. Respondent 4, my lord.
In the writ petitions.
private respondents.
Same Hardis. Respondent 4. the common response number 4. And whereas the beneficiary and by letter of acceptance. And a letter of acceptance was issued in his favor on 31/8/2022. Full stop. As per the NIT, the period of contract was for 3 years, either with effect from 1/4/2022 or at a they decided as per the letter of acceptance, that is 31/8/2022, a period of 3 years has already expired, and as such, the subject matter of the repetition has become infructuous. In view of the aforesaid position, the repetitions are disposed of as infructuous.
That's item number 40. I'm appearing for petitioner.
I am for 7 and 8 in this case.
Please, Your Lordship. There's only 7 was not served, but respondent number 8 had already put in appearance on, and they're the same juristic company. So now my friend is appearing on account of both 7 and 8. Other respondents have already put in appearance. Their reply is awaited.
What is the issue?
Plus, the issue is with regard to the forcible recovery of
Who is
vehicle.
respondent number 7 and 8?
Yes,
They are the private bank, Yes Bank, Your Lordships.
So you obtain loan for a vehicle.
Yes, Your Lordships.
Hmm.
And my instructions are, I've spoken to my client in the morning. He's been paying the installments regularly, subject to verification by my friend who's appearing for respondent number 7 and 8. But I can file an
Now,
affidavit to that effect.
why you have approached this court?
Well, I approached this honorable
Invoking
court.
writ jurisdiction?
Well, it's in a writ jurisdiction because there's a notification by Reserve Bank of India, which is binding on the non-banking financial corporations. That notification is before Your Lordships.
Recovery agent.
Yes.
But how they have recovered the
They've
vehicle
not
from you?
they've not recovered, Your Lordships, by virtue of an order of this honorable court passed on 18th of December 2024. I was
So everything
protected.
is to be done by as per RBI guidelines. Why you have invoked re-jurisdiction? In
Well, it's
apprehension. In apprehension.
Well,
And
it's
why you are
because
taking cover of this High Court order, writ court order?
well, there is no
Will continue to pay installments.
Yes.
Are we the moderator for loan installment?
No, Milords, not at all.
Will supervise your
Milords, my
regular
only,
payment of loan installment in favor of a private bank.
Milords, my submission before Lordships is the private bank because
Which RBI advisory?
Milords, that advisory I have appended before Lordships as an extra P4. It
An
is not
extra
an
P4?
advisory. It is a notification issued under Section
Whatever. Where is that?
45L of Reserve Bank of India Act. And there
Where
are
is
judgments.
that? Page?
Milords, I'll just give the page, Milords. Because Milords, the pleadings are not complete as yet. Therefore, Milords, I was under the
Whether this repetition is to be kept pending, with an observation that interim order petitioner will pay the installment as required in terms of the agreement. It is a complete private agreement.
Yes.
Between
It's a private agreement.
between the petitioner and the respondent bank.
Number 7 and 8.
And a writ court does not enforce any private agreement.
Milords, I'm extremely grateful that your Lordships have observed it. I'm not seeking a prayer with regard to
Where is the
enforcement of a
Reserve
private
Bank,
contract.
Reserve Bank direction?
Milords, the Reserve Bank directions are an extra P4 before your Lordships.
Page.
37.
Huh?
37.
37. If anything to be done, is to be done by this only. This is
Please,
the
Your Lordships.
procedure law as per the direction of the Reserve Bank of India Master Circular Fair Practices Code. That's
Yes, your Lordships. That is the precise argument.
You are on the
that-
apprehension that the recovery agent will be employed.
And not just
For
apprehension, my
recovery.
lords. There are various instances where they have
No,
recovered it.
that does not mean that it will be done to you.
My lords, they have not done it only because I have a protection from this honorable court. If they
No,
make
this
an
is not the way to do protection. We'll say that any action needs to be taken by the respondent bank with regard to the loan account of the petitioner for the purpose of the vehicle. It should be strictly in terms of the directions given in the master circular.
that would be
Well,
that would
as well as
suffice, your
guided by
lordships.
the agreement.
That
As
would
well as
suffice.
Guided by the agreement. Your Lordship.
No,
And as
not
per
just
the
by
loan
Loan
account
agreement.
agreement.
Yes, sir.
not
That's
just
all.
not just the agreement, my lords, that would suffice,
Both,
but also
both.
with regard to Reserve Bank of
Both.
India guide. Both. Yes,
Loan account
that would
agreement is
suffice.
definitely.
I'm so grateful. That would suffice, your lordships.
That's all. You have appeared 7 and
7
8.
and 8.
Okay, hard, Mr.
Karan Bharatwaj, your lordships.
Karan Nahata.
Lords Bharatwaj. Karan
No,
Bharatwaj.
K. Bharadwaj.
K.
Learned
Bharatwaj.
counsel for the petitioner to the virtual mode, along with Mr.
Lords
M. Hawk.
M. Hawk.
Learned counsel for the petitioner. Mr. J. Hendrik, Learned Junior Government Advocate Assam for the respondent number 1 to 4. Mr. P. Hajorika, Learned counsel for the respondent number 5 and 6. And Mr. M. Sharma, Learned counsel for the respondent number 7.
7 and 8.
Full stop. Para. It is the case of the petitioner that the petitioner purchased a vehicle bearing registration number NL01AE8302 after availing financial facility from the respondent number 7 through respondent number 8, right?
Yes, sir.
And the financial facility availed was for a sum of rupees 39 lakh
Please, your lordships.
77,666. Full stop. The petitioner stated that out of the sanctioned financial amount, sanctioned financial amount, only an amount of rupees 38,82,435 was disbursed to the petitioner. And the respondent bank did not disburse an amount remaining, the remaining amount of rupees 95,231. Full stop. But as per the loan agreement executed by the petitioner and the respondent bank, the petitioner was required to repay the loan amount along with interest in 58 equated monthly installments within bracket EMIs of rupees 86,480 from 8/5/2021 to 8/2/2026. Full stop. Para. In the writ petition, the petitioner has averred that the petitioner had already, at the time of institution of the writ, in the writ petition, the petitioner has averred that at the time of institution of the writ petition, the petitioner had already paid an amount of rupees 30,39,425,
Please, your lordships.
which include debt, an amount of rupees 21,66,630 towards principal, and an amount of rupees 8,72,795 towards interest.
Please, your lordships.
As per the account statement provided to the petitioner on 15/10/2026, only an amount of rupees 5,92,735 was to be repaid to the petitioner. Full stop. The petitioner has approached this court with an apprehension that due to the respondent bank authorities are contemplating to take custody of the vehicle, subject vehicle, with the help of recovery agents, which procedure is not in conformity with the directions issued by the Reserve Bank of India in a master circular that's Hair Practices Code dated
28th of
1
September 2006, Your Lordships.
28th
of September 2006, Your Lordships.
2006
Yes,
and
Lord. 11th of April 2011.
and a line of decisions of the Honorable Supreme Court of India, more particularly in Manager ICICI Bank versus Prakash Kaur and others reported in so and Kamal
Kaushal Kishore, my lords.
Kaushal Kishore
Versus State of
versus
Uttar
State of
Pradesh.
Uttar Pradesh and others 2023 4 SSC 1. Post of Para Mr. When the writ petition was moved. Now, when the writ petition was listed on 18/12/2024, in the writ petition, notice was issued to the respondents on 9/12/2024. Post of on 18/2/2024, an interim order to the effect that the petitioner will continue. That the bank authorities shall not take steps to recover the subject vehicle from the petitioner. And the petitioner would continue to pay the installments as required in terms of the agreement. Post of. Yes, what is your submission?
Your Lordship, we are not doing anything that can be termed as
Mr. Sharma, learned counsel for the petition has submitted that as the petition is found paying.
No, Your Lordship, he has paid only at the initial stage when the interim order was passed. Thereafter, he has not paid.
Good. Has submitted that in the Mr. Sharma, learned counsel appearing for the respondent was 7 and 8 has submitted that in the event the respondent bank or authorities takes any decision for recovery of the vehicle in the event of default on the part of the petitioner to deposit the EMIs in terms of the loan agreement, then such recovery will be in strict terms of the master circular dated so and so of the Reserve Bank of India and in adherence to the directions given by the Honorable Supreme Court of India in
ICICI Bank versus Prakash Kaur, Your Lordship.
Prakash Kaur, Supra, and Kaushal Kishore, Supra. Full stop.
As well as the loan agreement. As well as the loan.
Already said.
Yes.
Already said. And in terms of the steps contemplated in the concerned loan agreement. Full stop. Para. As the respondent number 7 and 8 is found to be a private sector bank.
Private.
And loan agreement entered into by the petitioner and the respondent number 7 bank is a private agreement in respect of which this court in the jurisdiction cannot alter the terms and conditions of such private agreement.
Lords, may I submit if Your Lordships may permit?
Yes, that is my observation. You go and argue before the Supreme Court.
No,
It's a
Lords,
contract which
that's
is not to be
what-
enforced is a contract of private nature which is not to be enforced in the public law remedy of each jurisdiction. Because I mean, the aforesaid view of the matter, this court does not find to keep any reason to keep this petition pending, save and except observing that in the event the respondent was 7 bank, respondent was 7 and 8, contemplate to take recovery of the subject vehicle, then the same must be in strict adherence to the master circular dated so of the Reserve Bank of India and the directions issued by the Honorable Supreme Court of India in Prakash Kaur and Kaushal Kishore Supra, and plus the loan agreement entered into by the petitioner and respondent number 7, respondent bank authorities.
Your lordship, one small correction, that is where the amount has been mentioned as 592,735, it is an overdue amount.
He has said, I have not made any comment. He has stated. I have said he has stated.
Yes, no, it is stated in the.
We are not in the writ petition.
Yes.
I have not made any observation on it.
Yes. Hello.
Milords, my,
interim order may be
if your lordships may permit me,
The
my
interim
only,
order,
Milords, my only submission is
if any, passed earlier, the interim order passed earlier stands recalled. This order disposes of the writ petition.
Milords, my
41.
only submission is once the statement has been made by the bank, Milords, to say that the writ petition would not be maintainable under public law remedy, Milords, that would, if your lordships may not say so, Milords, because that would impact the other matters wherein the recovery has been made, and those matters are also coming up
No,
before
this
your
court
lordships.
already held. So if I refer to my judgments, then it will be more difficult for you.
That's that. That's
So I have already held.
Milords, my difficulty is that I'll be
This
coming
court has
again
already
in those.
held. I have already submitted his submission, recorded his submission, and private contract. Though this is not an enforceable terms and
Milords, there are matters wherein laws recovery is already made, and in those cases we are before your lordships. Milords.
Your limited relief can be only with regard
That has been
to
taken care of, Milords.
that has been taken care of.
That has
If
been
you
taken
go
care of.
deep into it, then you'll be in trouble.
Please, your lordships. Grateful. Extremely grateful.
May I beg your lordship?
Yes. Amended cost title
My lord, amended cost title, my lord.
submitted.
No, my lord.
No.
2 days time may can be granted.
Mr. A.R. Taludar, Learned Counsel for the petition, has submitted that the amended cost title in terms of the order of this court or Lojima court
Lojima court, my lord.
of the order dated 19/3/2026 of the Lojima court will be filed within 3 days' time.
My lord.
Post of. If such amended cost title is filed within 3 days' time, the office, the registry will carry out the necessary correction in the cost title as well as in the CS, and thereafter release the case.
After vacation.
After on a date. No, I'm going to carry out the necessary correction. Post of release the case after submission on a date. Release the case immediately after such amended cost title and corrections. On a date to be fixed by the office. S.S. Roy, write the names. S.S. Roy, Government Advocate 3, Mr. Ghosh, on behalf of S. Dr. PNRD, number
1506.
P. Castro,
NB.
NB Castro, R. Dubey. Yes, Miss Bhuya, you are there. Oh, okay. Our for the respondents are present.
42.
42, she will receive instruction.
Hmm.
My lord, they are whatever would
You are
be
for
would
both
be
the
advised to
you are for both the respondents.
lordship.
Okay. Heard Miss D.B. Guhan.
DB Gauhati.
Learned Counsel for the petitioner, Miss.
Lordship, but it will take some time. Within this month, the fund is this already. Likely to be received, my lord.
Imam proposed in favor of petitions. It is for what?
Lordship, that
Payment.
yes, yes. Upon verification, the said demand proposal submitted in respect
Okay,
to-
I am granting you 4 weeks time.
Immediately after.
Ms. B. Bhuyan, and Senior Counsel and Senior Standing Counsel BTC, along with Ms. has submitted that. I said by Ms. So-and-so has submitted that. She has instruction to appear on behalf of both the respondents. And the Ukalanama will be filed or has already been filed.
No, number five.
And the Ukalanama has already been filed. Full stop. Ms. Bhuyan has sought for 4 weeks time to in order to obtain necessary instruction.
No, no,
and-
Lordship, I've received it.
Huh?
This is my instruction.
Compliance or what?
Yes, they need, Lordship, within this month, the fund would be received. Demand has already been submitted.
Okay, has submitted that the demand proposal has already been submitted and
It is in order,
Uh,
my lord, and fund would
he
be.
has sought for listing of the case after
All
1 month,
days after-
4 weeks, in order to place up-to-date instruction. In view of the same, let the case be listed on SOIS. The instruction placed by Ms. Bhuyan is kept with the case record.
Part of office.
Item 43.
Mr.
Say SP sir.
SP Sharma, learned counsel for the petition is present. Mr. Roy, you are for?
2 and 4, Lordship. 1, 2 and 4.
Okay, Mr. S.S. Roy, learned counsel for the junior government advocate for the respond number 1, 2, and 4 are present. As per order dated 3/6/2026 of the Loajima Court, service of notice on the respond number 3 and 5 is complete. Anybody left?
No, Lordship.
As all the respondents are duly served with notices, let the case be listed after on so and so after vacation given date. In the admission column, the state respondents shall make endeavor to file the counter affidavit in the meantime.
Item 44.
As per dated 8/5.
And Mr. Ali.
MZ Shah on behalf of.
MZ Shah, learned counsel for the petition. Who are the respondents?
For
respondent number 5.
5. Ms. B. Sharma, learned Central Government Council for the respondent number 5. Full stop. As per order dated 11/6/2026 of the Loajima Court, service of notice on the respondent number 1 to 4 is complete. Full stop. None has appeared for the respondent number 1 to 4 till date. Full stop. As all the respondents are duly served with notices, let the case be listed on so and so. In the admission column, the respondents number 1 to 4 is open for the respondent number 1 to 4 to file the counter affidavit on their behalf in the meantime.
Respondent number 3 is completed, Lordship. I have taken.
1 to 4 already, I have said.
27 July.
All are service is complete.
27.
Admission column. Next.
Item 45.
Yes, Mr. R. H. Chaudhary.
Yes,
And Boduloy.
Lordship, as per office note dated.
Who is there standing as a PWD?
Delivered.
Who is for a PWD?
PW. I am for PW.
Miss
And Bormon on behalf of DNAT.
Dinat.
Yes, ma'am.
Okay, line standing out. Respond number 2 and 4. Mr. Dinat is there. Standing counsel PWD 2 and 4. Government advocate S.S. Roy 3 and 7. Mr. Ghosh, A.K. Ghosh on behalf of Mr. S. Dotto, Panchayat and Rural Development Department for the respondent of 5, 6 and 8. Yes, what is the order?
Lordship, as per middle portion of the office note delivered, your Lordship, to the private respondent. Speed post tracking report.
In view of the office note dated 11/6/2024, let the case be placed before the Law Jima Court for a report as regards service of notice upon the respond number 9 and 10 and to list the case on so and so with a report on the Law Jima Court. Before that, I got video. Okay, 27. The other respondents shall make endeavor to file their respective counter affidavits in the meantime. File your affidavit within July.
May I please, Your Lordship? In compliance with the last order, I have taken the steps and a notice has been issued to all the respondents.
Which part of, okay.
Lordship, I have received the instructions. It is regarding a railway plot of land where GMC authorities are constructing a community hall. And their case is that it is unauthorizedly they are doing, but it is with permission of railway authorities. A MOU between GMC and railways are there, and we have given no objection to GMC authorities.
Lordship,
Okay, let me take care of the listing of this case in the order column. We'll post it in the next week.
Lordship.
In the admission column. Heard, Miss
H.G. Das.
H.
G. Das.
G. Das, Learned Counsel for the petitioner. Miss B. Sharma, Learned Central Government Counsel for the respondent number 1. Mr. D. Nath, Learned Senior Government Advocate for the respondent number 2. And 4. Okay, Standing Counsel PWD. Mr. P. Nayak, Learned Standing Counsel GMC for the respondent number 3. Post up. As per office note dated 9/6/2020, in view of the office note dated 9/6/2026, let the case be placed before the Law Jima Court for a report as regards service of notice upon the respondent number 5 and list the case thereafter on in the admission column on next week. The instruction placed by Miss Sharma, Learned CGC for the respondent number 1 is kept with the case record. That they will decide admission.
Did they decide?
If it is permitted, madam, you have no cause of action to espouse. If railway authorities and the GMC, they have entered into an agreement, then you have no cause of action to espouse.
Let the matter come up.
Construction is also over.
Let them admission column, respond number 5 already served, then we can take proceed the matter with further.
26.
You free to.
I wasn't experienced. The matter is about,
What kind of matter it is?
it is a GST matter, Lordship.
GST matter.
GST matter, that means the penalty has been imposed upon the taxpayer for a default of the seller.
No, what is to be done today? It is that whether it is covered or not covered.
Not covered, my lord.
Not covered, then we'll hear it out on the another date.
Covered. In my opinion, it is covered.
So I have to hear it.
Yes.
If your contra view is there.
My lord, say Sokos is under challenge, my lord. He is yet to respond, my lord. Then we can decide, my lord.
Are you protected with any kind of interim order?
No interview.
You are outstation council,
No.
local council. Okay, we'll hear it out on a fixed admission date. On a hearing date, Mr.
Yes, my lord. Let it be in any day before or after, nothing.
After that, because next week will be again motion days.
Lordship, my firm is closed since September. I am not being able to do the business.
You may not have been able to make out a primary case for interim order,
No, Lordship, my case is covered.
but he is objecting.
He must be objective. He was the counsel in that
Okay,
case also.
which judgment? Give the judgment,
National
your
Plus two.
national plus 2
National
copy, give us, we'll keep it, we'll try to read it and come prepared. And what is anything you rely upon?
Otherwise, my lord, maintainability point, my lord, Godrej Harali and all I will place, my lord. In fact, lordship's order is there, my lord, in this regard. Sokos has been put to challenge, my lord.
Okay, so-called,
Sokos.
only so-called is.
No. The Sokos has been already decided. They have issued a.
Your
demand
name
notice.
is MD Khan.
MD.
Your name is MD Khan
MD Khan.
for the petitioner and B Gogoi. Mr. B. Goel and Standing Council Finance and Taxation Department for the respondents.
Right.
Are present as sought for by the conservative parties, leaves the case on next week. We'll try.
Lordship.
If possible,
Yes.
if possible, we'll try.
No, Lordship.
If not possible,
Yes.
no, by this time I get exhausted.
Yes.
Basically, it is, if it is, it's in the upper half of the list,
First of.
I can apply my mind. By this time, it is not possible to
Lordship.
apply my mind to national plus two or whatever.
My lordship.
23 will make an attempt,
23rd.
but if possible.
Lordship.
Otherwise, immediately after vacation.